Welcome back. We're just going to continue the hearing from last week on this jury survey. And not quite sure what to expect today. Since we had the hearing last week, I had a chance to take in everybody's comments, see a lot of different perspectives on this issue. And I got to tell you, some of them surprised me a little bit. But I've also had a little bit of time to kind of let my thoughts congeal a little bit around some of the concerns that I have about the direction this hearing appears to be going. So I wanted to go ahead and start by just recapping where we're at, what happened. So last Thursday, Judge had a hearing in court on these competing motions from the state and the defense. The state is asking to put a hold on this jury survey, the survey of prospective jurors in Latah County that Bryan Kohberger's team has been doing. And Ann Taylor had filed a cross motion complaining about the way in which the order stopping her survey from happening, at least temporarily, was entered without any kind of notice to her. The hearing was kind of wild, little firecrackers, I guess, just a little bit more enlivened than I think we're often accustomed to seeing in these types of processes. Lots of people upset, excited, waving their hands, pounding the table. Prosecutor Bill Thompson is extremely outraged about these questions and making that clear. Judge is deeply offended at being accused of violating the due process rights of Bryan Kohberger. And Ann Taylor doesn't seem to be too pleased at the implication that she has violated the gag order and simultaneously her ethical duties as a lawyer. With the types of comments that I guess in the questions that were asked in this survey. So a lot of stuff going on, and it got a little bit crazy, a little bit wild, and we didn't get any real resolution from that hearing. We didn't get an order. We didn't get findings. We don't necessarily know for sure how this is going to go. We didn't hear from the expert, the guy that's actually conducting the survey. Don't know if that's going to be an option today either. So where we're left with is just this overall impression that the judge and the prosecutor are pretty much on the same side. They don't like these questions that were asked. And the problem with them was that they were quite specific about exactly what information they wanted to know if these prospective jurors had heard. Now, we haven't seen the entire script of the survey, so we don't know exactly how it is given. We don't know if it's like a decision tree where if a juror answers that yes, they've read about the case or they've seen information about the case, that it leads them in this direction to where they might be asked specific questions. Just all of these kind of lack of clarity at this point about exactly how this thing is administered. So, but it sounds like, from what we've seen, the real issue everybody has is just these questions are being asked. The state thinks this is going to taint the potential jury pool. The defense is saying, we need this information to be able to get our factual record for the change of venue that we anticipate requesting. And this stuff is already out there in the public arena. So when we talked about this last week, my focus on it was really on the language of the gag order itself, and that provision there in section 2B that kept screaming at the screen, 2B, somebody please bring up 2B, because that's the one that says the attorneys may specifically make statements about information that is contained in the public record. And so, as Ann said in the court hearing, they didn't even provide this survey expert with any information about the case. He got everything that he needed from media reporting about the case. So all of this stuff is already out there in public. That would seem to fall pretty squarely under that subsection 2B of the gag order. But as I've had time to kind of sit and think about this a little bit further, my concern goes a little bit. It goes a little bit deeper. I am concerned that if the judge is cutting off the defense questioning the way that they want to do it, that's potentially an appealable error. And so I want to talk about why. We're in the United States, and so given that, the presumption is pretty much everybody gets to say whatever you want to whoever you want about whatever you want. Okay. First Amendment, very broad free speech protection. And obviously there are exceptions to that, but lawyers talking about their cases is not an exception to the First Amendment. Lawyers talking about their cases have First Amendment rights as well. So at the same time, we recognize lawyers have a particular position in the justice system. There's a real possibility of prejudice to fair trials if attorneys can just litigate their cases in the court of public opinion rather than in the courtroom. And so the US Supreme Court has recognized that. But there is a case on the limits of being able to basically restrict attorneys' speech about pending cases. That case is Gentile versus State of Nevada. And it sets out the standard for when the court or a government, a state bar association or whatever, can put restrictions on attorneys talking about their cases. And that standard is very clear. There has to be a substantial likelihood that the statement will cause material prejudice to the defendant's right to a fair trial. So that's really that's the key. That's the key to whether or not an attorney talking to somebody, an attorney questioning a witness, attorney talking to somebody out in public, attorney asking them questions about what they know about the case. That's the key that you have to ask. If it doesn't meet that standard, the court cannot restrict it, or it is violating the First Amendment. If it meets that standard, then the court can restrict that. So then you look at, well, what does that mean? A substantial likelihood of material prejudice to the right to a fair trial. Well, the case kind of talks a little bit about that too. That particular case involved a criminal matter where basically shortly after the indictment, the attorney who's representing the defendant, there had been all kinds of publicity about this case, stuff about it. Guy gets indicted, attorney representing the guy goes in and calls a press conference and makes a public statement. And he basically says, my client is innocent. The other suspect is this police officer. The witnesses against my client aren't credible for a variety of reasons, but mainly because they have their own, they have to protect themselves. They've cut deals with the prosecutor kind of situation. And so ultimately, the case goes to trial. The client ends up being acquitted, but the state bar goes after this attorney and alleges your statements that you made were unethical. And so the US Supreme Court looked at that and they reversed it. And there's a lot of things that they look at. It's a totality of the circumstances test when they're considering, is this statement, does it cross the line of that particular standard? And so what they're looking at is they're looking at the magnitude of, how serious is this information that's being put out there? Like, how big a deal is it? They look at recency. They look at the timing of the statement. And so in that particular case, things that were of critical importance were the fact that pretty much everything that the attorney had already said in his press conference, it had already been reported. It was already out there in public. So that was very significant. They thought there's not much prejudice to this. There was a large jury pool. This was in Clark County, Nevada. So, something like 400,000 people that they're going to be able to draw the pool from, the jury panel from. So unlikely that, everybody is going to be disqualified as a result of that. And then the last thing, it was 6 months before the trial. And the court held that was very significant because after 6 months, people forget things. You're not going to necessarily remember the details of what you saw in the news. And then the thing that I think would come up in this particular case with this particular community, you're going to have population change. People move and people, come and go, especially it being a university town. So you're not going to necessarily have the same people in your jury pool 6 months down the road, a year down the road, as you're going to have at the time these questions are being answered. So that's the standard. That's how the court applies it. And looking at this particular situation, I think that's probably, I have serious doubts that it would meet that standard under under the way that the U.S. Supreme Court has previously applied it. So that being the case, the rest of the gag order, all of the specifics about you can say this, you can't say this, from my perspective, you can kind of throw all that out. It doesn't really matter. The only way you can enforce it is if it meets that standard, substantial likelihood to cause material prejudice. And I just don't think it's going to meet that standard under the facts and circumstances we have here. It's a year from trial. It's 1% of the jury population. They can be removed from the panel. And it's stuff that's already out there in the public record. It's already been reported. So, yeah, I think this could be a First Amendment violation. That's my take on it. If this were a case that were, coming to me and landing on my desk for an appeal process, and I'm reading through this in the transcript, that's going to be something that I'm going to spot. And I'm going to look at it. If the judge does not allow the defense to complete the survey, and that is a constitutional error, with constitutional errors, the burden is on the state to prove that they didn't have any kind of effect on the trial. They weren't harmful in any way. And so that's a tough standard to meet. But I'm going to be thinking, if I'm Ann Taylor now, I'm going to be thinking down the road about, well, how do I make my record? What do I need to be able to show a future reviewing court? This is what I was trying to do. This is why it was incorrect. And this is how it impaired me from being able to do my job as a defense attorney for my client. So those are kind of some of my initial thoughts about where we're at here. I got to kind of keep refreshing this page to see if the hearing starts, because they like to just bring it up by surprise. But so I'm trying to keep an eye on the comments and see what's going on here. Welcome, everybody. Thanks, Jeff, for getting that citation in there. Yes, it's Gentile versus State Bar of Nevada, 501 U.S. 1030. So that's a big case. It came up as well, as a matter of fact, in the Johnny Depp stuff, because, in fact, I'd like to make a video about this. You can tell me if that's something that you'd be interested in hearing about. But the whole removal of Adam Waldman from the case, it always really bothered me that the First Amendment side of Adam Waldman's right to speak on behalf of his client, didn't get pushed. And it seemed to be a situation where you have local counsel that's in the courtroom dealing with these people. We'll have to do that again in the future. And so, we talked last week about how there's a little bit of a go along to get along attitude that can happen sometimes in the courtroom. Everybody kind of wants to make everybody happy and not really make any waves. But then on the other hand, you had this guy who is Johnny Depp's personal lawyer, who has, spent years now trying to correct the public record, given all of this, all of these accusations that were out there. And he's trying to basically, swing the perspective on Johnny Depp and his kind of assumed guilt for a number of years. He's trying to swing that pendulum back the other way and get people to open their minds back up to, hey, here's these audio recordings and stuff like that. There really is a whole other side to this case that you may want to listen to. That had very significant First Amendment implications, what he was doing. And that type of thing is talked about in Gentile. The court actually had some pretty strong language where he says, the attorney's job doesn't start at the courthouse door. In fact, I'll just read it. It says, he or she cannot ignore the practical implications of a legal proceeding for the client. Just as an attorney may recommend a plea bargain or civil settlement to avoid the adverse consequences of a possible loss after trial, so too an attorney may take reasonable steps to defend a client's reputation and reverse reduce the adverse consequences of indictment, especially in the face of a prosecution deemed unjust or commenced with improper motives. A defense attorney may pursue lawful strategies to obtain dismissal of an indictment or reduction of charges, including an attempt to demonstrate in the court of public opinion that the client does not deserve to be tried. This is the US Supreme Court, guys. Like, they're not saying, okay, go ahead and go out and litigate your case in the court of public opinion and forget about the courthouse. But they are making it pretty clear that, yeah, your job as a lawyer includes more than just showing up in court and, you know, making the pro forma arguments you need to make. There's other things that you have to consider, and other aspects of just public perception that you might be required to deal with given the circumstances of your particular case. So anyway, this, you know, as it sometimes happens, issues kind of recur over these different cases. And so that had come up, as I mentioned, with the Adam Waldman stuff and the Johnny Depp case, and kind of always, you know, meant to talk about it and just have never had the time. But I think it might be something fun for us to go ahead and take a look at. So anyway, just continuing to check the stream, and it looks like they are running a couple minutes late today, but that's okay. Oh, I see Kurt's in the chat. Hi, Kurt. Welcome. Thanks for being here. And I saw Ian stopped by. Hi, Ian. I'm going to, guys, just so you know, I'm going to try to stop by Ian's stream later tonight once we wrap up here. We don't know how long this hearing is going to go. I'd be a little surprised if it goes much longer than about an hour. So then I'm, you know, anticipating we'll talk a little bit after that about what happened and what it means and stuff like that. But I do plan on joining Ian later this evening. He's going to be streaming starting at 6:30 Pacific time. So if you want to catch me there, I will be there. And still just waiting for the hearing here. Yes, I see in the comments from Matt, I'm hoping to hear from Bryan Edelman today. Matt, me too. I really would like to hear from Bryan Edelman, not just because I want to know. I think that there should be a defense case on why these questions were asked the way that they were. Why does it need to be that way? And you know, not have them just be on this defensive where it's kind of conceded or just taken for granted that, yeah, these questions are a problem. I don't think these questions are a problem. These questions have to be that way for a lot of reasons. And you know, they've talked kind of in general terms about some of that. Oh, looks like
Mr. Kohberger is here in the courtroom, represented by Ms. Taylor and Ms. Mathis. We've got Mr. Thompson, Ms. Jennings representing the state. Can you hear me okay?
Yes.
Yeah, okay. I think we have Mr. Nye and Ms. Beatty on Zoom. Anybody else on Zoom? Ms. Taylor?
No, Mr. Logston is not going to be on Zoom today. He had the other hearing.
Ms. Beatty made it apparently. So, and I have also, you have Mr. Edelman, Dr. Edelman here today.
I do, Your Honor.
Okay.
good.
Great. So
Great news.
I think what we're doing today is just a continuation about the questions, particularly on the surveys and where we go from here. You did drop off a sealed exhibit, right? And anything to say about this or just?
Yes, Your Honor. That sealed exhibit goes with one of our discovery requests, that the exhibit that outlines what we're requesting has to be under seal. And so I had to hand deliver that to the court. A copy was hand delivered to the state. It is not up for discussion today.
Okay, great. Thank you. One other thing that this tie up is the order unsealing the state's motion for order prohibiting contact with prospective jurors. There was a discussion between both of you about redacting a particular sentence maybe last time. And so that we were going to take care of that.
I didn't, Ms. Taylor indicated that there was a sentence she thought we might want to consider redacting. I haven't heard back on that. And I know that she's been busy on other things since the 6th.
Just
Since you caused these problems, yeah, she's been busy.
I understand the microphones in the courtroom are very sensitive. Perhaps we should do this after court today and go ahead and do the testimony of Dr. Edelman first. And I'd be happy to talk to the state afterwards.
Right. All right, so is that where we're starting now?
Yes, Your Honor.
Actually, Judge, I think we need to discuss some preliminary matters first.
Okay, go ahead.
As Your Honor indicated just a moment ago, this is a continuation of where we were on the 6th. And the issues on the 6th and the issues that we have here today is first, whether there was a violation of the non-dissemination order. And if so, where do we go forward from that point? And I think it was clear from our discussions on the 6th that the fact-specific questions did violate the order. I realize that the defense would like to proceed with those questions. That's perhaps an issue for today. But I just wanted to define what we're looking at today, because about 10:45 this morning, we got what was up on the screen there, a PowerPoint that apparently Mr. Edelman prepared. And as I understand, I don't think Ms. Taylor got it until sometime this morning herself. That's the information that I was given. And we have concerns because a large part of this PowerPoint deals with the issue of a change of venue itself, which is we are not prepared to address. It is not before the court at this time. It is premature. And I don't think that it should be part of this record as we proceed forward today. And so the state took a copy of preparing a printout of the PowerPoint. It doesn't take long to look through it. Perhaps the court might want to take a look at that before we proceed, at least with eliciting things from the PowerPoint.
So we're going to
I realize it's last
pre-object.
minute, but the last time that we presented something to the court in advance, Ms. Taylor complained profusely. And I realized it was only 10:45 when we got this today. And so we just figured we would raise it with you now.
Okay, thank you, Mr. Thompson. Ms. Taylor?
Your Honor, I would disagree with counsel that the court made a determination that we violated the non-dissemination order.
Thank you,
In
Anne.
my mind, that issue is very right for the court today, as is where do we go from here with the survey? Dr. Edelman has made himself available in court to explain the survey, the process of the survey, why it works, how long it's been used, how widely it's used, and what it doesn't do, and what it does do to present the court with some options to make a decision where we go from here. Whether the court decides we violated the non-dissemination order or not is up for discussion, and we're prepared to further argue that, but we think you need to hear the testimony first.
Thank you.
As far as this
Go in.
PowerPoint, I had access to Dr. Edelman yesterday afternoon and we worked on it late. I didn't have a final copy to give to the state until this morning. So they have it. We are not arguing venue now. We're talking about survey and how that relates to our change of venue motion. We know we're arguing the venue change later, but we have work that we still need to do. And that's where we are today, and would ask to present our PowerPoint and present our testimony with Dr. Edelman as we've prepared to do.
Okay. Taylor, so
Actually, Ms. Taylor still has a copy of the PowerPoint that I made available to the court.
okay, so seems like this happens to me in this case that there's an argument about whether I should go ahead on something or provide some information that I don't see yet. So I feel like sometimes I'm making decisions that I'm in the blind here.
Well, that's why
So,
you should require them
I'm gonna
to
look
make
this
their
over.
objections
Any
when the
problem with
evidence is
that?
presented.
Well, Judge, give me just one second.
Reserve on it, Judge.
Your Honor, the purpose of the PowerPoint is to inform the court about the questions in the survey and the purpose of them. I can tell the court that showing up every time we want to have a hearing and have to fight to have the actual hearing is something I haven't experienced before either. There is nothing in that PowerPoint that the court can't hear today when making the decision about where do we go from here and did I violate the non-dissemination order. There's just nothing wrong with the process that we're doing here, and you're continually being asked to say there's something wrong with what we're doing. We're 10 after 4. I have a witness who's traveled here today, and we're ready to go.
Thank you,
All right,
Anne.
Your Honor, just to clarify, as we made clear the last time we report, we are not saying Ms. Taylor herself violated the non-dissemination order. We're saying that the people who prepared the survey and disseminated the survey and called citizens of Latah County
Doesn't
with
matter.
those
They're agents of the
fact-specific
defense.
loaded questions violated the non-dissemination order, and they are agents of the defense. So I don't want this to become personal between Ms. Taylor and myself. We are not alleging Ms. Taylor has done anything wrong. We are dealing with reality that this survey was conducted on, as we understand it, 400, I'll say, innocent citizens of Latah County who were force-fed information that they may or may not have had about this case before they were called by the surveyor takers. And they are loaded questions.
And we
Some of the
know
questions are
that you want
factually
that to
wrong.
be
They
the
simply
official
aren't
version
true.
of events,
That's what we're here about.
which is why she wants to put her
And that's what
expert
we're
on.
prepared to address, Your Honor.
about
That's
who
why
was
we
quote
have
unquote
a witness
force-fed.
here. And if there's violation of the non-dissemination order, it's me. I'm the one that's bound by it. And the court just needs to hear about this process instead of hearing the conclusion that the state wants the court to reach.
Yes.
Number one, I'm past that. I'm not gonna violate you. I mean, this was a communication problem with Dr. Edelman not getting the order. One of the things I think that maybe you need to clear up, not for counsel, but maybe the public, is that one of the terms in that, and this is in the ethics, right, is what is the public record? Public record is not traditional media. It's not social media. It's not what anyone might say in public. Okay, that's the problem that we're kind of balancing here, because
If that's not what it is,
the public
then your gag
record
order's
is
got a problem under the
case
First
that
Amendment.
is available to the public in this case. I mean, I think we can all agree with that. No? You think the public record is whatever the media pumps out?
Your Honor, I think it's what's in the public, and what's in the public is derived from the affidavit that supported probable cause to arrest Bryan Kohberger. That's the first document that the court finds in the whole cases of interest on Idaho State Supreme Court's website. That document has a ton of information in it that relate to the questions in the survey for the case-specific questions. So that document became public record, and that was spread far and wide all over the place and reported and interpreted repeatedly. That's the public record. That's where the questions came from. There's no violation of the non-dissemination order if that's what we're going to talk about today, but I think the court should hear from our witness and understand a little bit more about this survey process.
Yes.
I'm very interested in that. I told you last time that I'm interested in what he has to say about this, but so you're saying that the public record though comes out of the case, right? That's public.
I'm saying in this case, that's exactly what happened, Judge. I don't want to argue the finer points of what's in the media, but I'm saying in this case, that's exactly what happened. That affidavit's there, and This court knows we have a ton of things that are filed under seal and more things that are not filed under seal. But that affidavit that began this case has been shared far and wide, and media stories have generated. When you understand how Dr. Edelman does his work to determine if a survey even needs to happen, you'll know where the information came from.
Okay, so I'm understanding, okay, the initial probable cause affidavit is part of the public record. And you're saying, well, that got spread, okay, by the media, as you would expect. And that's something that could be concerned. So what I think
Judge, you can't gag them from
Mr.
talking about the
Thompson
media.
is talking about, though,
Surely you
is,
get that.
information or questions that were not. And so what I'm nervous about this is I don't want to continue to spread things out that shouldn't be spread. And so I don't know what's in the slides, but if there's information in the slides that are not in the public record, that really have not been disseminated generally, then I mean, I don't really want to spread it. None of us want to spread it more than necessary.
But it's already spread.
Well,
So we have to ask
last
about
week
it.
in court, that was right inside the courtroom. That all became part of the public record. The 9 questions were stated repeatedly in different formats by Mr. Thompson. That's part of the public record. We've been accused of violating the non-dissemination order. Dr. Edelman's reputation has been impugned by what was stated about him repeatedly. Those questions are fair game. But having this hearing and allowing our expert to talk about this process, that's not the problem. The problem with the media happened a long time ago, and it started with the sharing of the affidavit far and wide.
I understand that. I'm pulled in 2 different directions right now because I'm trying to protect your client at the same time. So if we keep talking about this, what is not true, okay? I mean, I guess we can just say, well, it's not true on some of these questions. Maybe that helps to reduce bias.
Great. That'd be
But if,
awesome. Why don't you do
if we
that,
don't
Judge?
make that clear, then it could increase bias. I think. I don't know. Tell me. Maybe.
Well,
I'll hear this from the expert.
I'm going to say it like this. Mr. Kohberger is my client, and his rights are of the utmost importance to me. Him being treated fair, his presumption of innocence, him having an impartial jury, those are important things to me, as is his right to counsel. I am not standing up here saying, let me tell you about this survey. Let me finish this survey to hurt him. I'm saying there is pervasive media coverage in this case. It's prejudicial media coverage. We've conducted a survey in Latah County. That survey is going to show bias and that you shouldn't have a trial in this county. What I'm trying to do is say, do you want me to give you information about another place where maybe the bias isn't so great, where maybe Mr. Kohberger can have a fair trial? I'm his advocate. I want to help him. I believe in his innocence. I'm not going to stand in this courtroom and do anything wrong to him at all. I need you to hear the information so you can make a decision, to have the surveys, to have the information when we come back here for change of venue and make a decision on all of the information. Right now, if we come in and do our change of venue, we're going to say you can't have this jury in Latah County, but I can't tell you a better place that will protect him better. And that's what I want to do.
Any response, Mr. Thompson?
We aren't here to argue about venue today. We aren't here to argue about what this particular survey with the loaded questions, fact-loaded questions, may have produced in Latah County residents. As we mentioned last week, the structure of those questions assumes that every person that is called has heard all of the media in this case. And we know that that just simply isn't true. So for those citizens in this county who have not heard all of the rumors, who have not been following the media, who haven't inspected the court record, who are essentially ignorant of facts in this case, well, that's just been jaundiced by the questions that were asked. They have now been force-fed facts, some of which are not true, some of which would not be offered in court, and in fact, probably wouldn't legally be admissible in court to somebody who may never have heard them before. That's the state's concern about the way this thing is put together. And the arguments from the defense seem to be completely ignoring that point. That there are people out here who don't know all the things that they were being asked, and by asking the fact-specific questions, we were inoculating them with information that they didn't have before about this case that could affect their ability to sit as jurors. It's just simply irresponsible. It doesn't make sense.
Listen, this is one of the things that I was thinking about, is maybe we can inoculate by saying you can't rely on any of this information. It's not established by evidence. It's not been provided in court. But to just send a message out to be clear that these questions have nothing to do with guilt or innocence or even truth.
But that's not what was done, Judge.
I know. We have to fix this in some way.
Yes, sir.
That's what you said last time. And so I just want to help the public understand that this is not the trial.
Your Honor,
Yes.
at this rate, we may never get to trial. We know this isn't the trial. We brought Dr. Edelman to talk about the process, which will answer the state's concerns about this process. He hasn't even had a chance to tell you how this is constructed. He's the one that's the doctor of this kind of work. He's the one that's the professional. He's the one that knows how to do this. He's the one that spent his career understanding surveys and how to construct these. You need to hear from him.
Yes.
Going back and forth between what Bill thinks and what I think doesn't matter. What matters is you hearing from the expert to make a decision. He's here, he's ready to testify. We're 20 minutes into this hearing and he hasn't been allowed to take the stand yet. He came to inform the court about this process.
Well, there's no question I'm going to let him testify.
Good.
I just wondered about what's in this. I haven't even looked at this, but it's you're
Let Bill
comfortable
object.
having this come out
to the
into
slides.
public.
Yes,
As it comes
after last week's hearing, absolutely.
Okay, and you looked at it, Mr. Thompson.
You have
is it
concerns, Judge.
alarming?
Well, part of what's in there is a part of the survey study being published now, if this comes to the public without
so
any comparison
can't,
to anything
only
else.
you can.
And it's the product of these loaded questions. It takes us back to the fundamental issue of how this survey was conducted and the assumption that the people who were being called already knew all this stuff. And so it didn't hurt to specifically ask them, have you heard about such, the specific item? Well, if they hadn't heard about it before, they sure as heck have heard about it now. That's the core concern that led us to this in the first place. We don't dispute the defense doing a survey. I said that last week. Please do a survey, but don't go around screwing with the knowledge that prospective jurors have or may not have. That's our concern. And Your Honor, when we parted ways last week, the court said, Ms. Taylor, talk with Mr. Edelman and see what the options are. Well, my understanding from the email I received day before yesterday is the survey cannot be changed. That was from Ms. Taylor reporting what Dr. Edelman said. I interpret that as they don't want to change it. Anything can be done, but that's where we're left.
Why don't you ask him?
I would have
what
been
he
happy
said
to engage in discussion
instead of
with
putting words in his
defense
mouth.
about maybe some middle ground, but the line has been drawn black and white. I am concerned about the specific things that relate to venue, partial survey results that are in this PowerPoint. I believe it is premature for them to come out now. The rest of it is fine. let's bring it out so that you have whatever information you want. You can give it the weight that you decide. I just didn't want to let this willy-nilly
What,
come in
because maybe some of the details make it not look so bad?
in a half-baked fashion.
I have lots of concerns. We're not left with this, because I have to make a decision about several things.
Yes, sir.
And so in order for me to have the most informed, decision, I need the information. So you're just gonna go ahead. All right?
Thank you.
And you can show your slides, and if something is concerning, we can talk about it along with it. All right?
Yes.
So,
Finally.
are you ready to call your witness? I think you are.
I am. I'm ready to call Dr. Bryan Kohberger.
Okay, Dr. Edelman, if you could please come forward, face the clerk, raise your right hand. There you go.
You solemnly swear that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do.
All right, thank you, sir. If you could please, take your seat there. And then once you're comfortable, please state your name and spell your last.
It's Bryan Edelman, Bryan Edelman.
Thank you. Ms.
Thank you.
Taylor.
Good afternoon, Dr. Edelman.
Good afternoon.
What do you do for a living?
I work as a trial consultant, and also I do quite a bit of work as an expert witness in the field of pretrial publicity and change events.
Are those two separate roles?
Yes, they are.
What do you do when you're a trial consultant?
So as a trial consultant, you're an advocate for your client. You do mock trials, focus groups,
Are we frozen
to
here?
really try to develop a trial strategy, a trial story for your side, and cultivate that for the audience, the jury. We also do jury selection. I assist with writing voir dire questions, juror questionnaires, help ferret out bias.
Did we lose the stream?
During voir dire, recommend cause challenges, and
Okay.
how to use peremptories, do post-trial interviews. I do jury-related research, present my findings at conferences, bar associations, law firms, and so on.
When you work as an expert in the field of change of venue, does that differ from your work as a trial consultant?
Absolutely.
How so?
Well, as I mentioned, as a trial consultant, you're retained to be an advocate. As an expert, you are retained to be an objective expert, which means I'm not advocating for either side. I do not advocate for the defense. I do not advocate for the prosecution. My role is to collect information using standard methods that have been widely accepted in the field, and then present the findings to the court so they can make a well-informed decision on whether or not any remedial measures are necessary. So there are times where my findings support what remedial measures, like a change of venue, and there are times they don't. And when they don't, I recommend against a change of venue, whatever the data supports where I go.
I want to understand a little bit about your educational background that allows you to do that work.
Okay.
How were you educated?
I'm sorry.
How were you educated? What degree?
Starting in grammar school.
we can skip to college.
Yeah. So I have a bachelor's degree in psychology from Florida State University. From there, I attended the University of Nevada in Reno, where I studied social psychology. My particular interest was in the application of social psychology in the field of the legal arena. So I was really interested in juror decision-making, jury decision-making, group dynamics, how people process information and evidence, the pre-existing attitudes and that sort of thing.
Ah, we're getting very glitchy. Are we freezing up again? Okay. I'm but
Judicial College in that regard as well. And then from there, when I finished my PhD, I got a Rotary scholarship to study in the United Kingdom, where I got an LLM in international humanitarian law, which I do not use.
During the course of your career, have you been published?
I have. I've been published in this area of survey methodology. My research was on the death penalty, so I have a book published on the death penalty. I am the co-editor in California. There's something called the CEB, the Continuing Education of the Bar, and there's a criminal procedure book that comes out every year. It's kind of like the Bible for criminal procedure, and I'm a co-editor on the chapter on change of venue. I was also on the committee for the American Society of Trial Consultants that publishes professional guidelines for writing change of venue surveys. So I'm on that. And I've also done research on, one of the questions is always, well, why can't we just pick a jury in a high profile case? So I've done research on the use of the set aside question. So if people have been inundated with a lot of prejudicial media coverage, how do they respond to that set aside question? Do we see, for example, if somebody's been exposed to a lot of prejudicial coverage, you'd expect them to say, I cannot be fair and impartial, I know too much. And so we were looking at research on that as well. And then last thing I promise is, I've also done research on what's called minimization language. So when you ask people an open-ended question on a juror questionnaire or in voir dire in a high-profile case, this is the only standard question, what have you read, seen, or heard about this case? That's the open-ended question. And people minimize what they know. That's something Dr. Ed Bronson came up with because he had noticed it. And that's like using language such as, I only recall what was in the paper, or I just followed it. I just remember it was on the news. And they don't really elicit a lot of information. It's minimized knowledge. So did research on that.
That's been part of your research?
Yes.
When you work as an expert, if you're hired as an expert to work on a change of view issue, and I think you told us how your work is different than when you're a trial consultant. Can you tell me how you start in that role as an expert for change of venue?
Yeah. So first of all, I've been doing this for about 15 years, I'd say, as an expert witness on this area.
On change of venue specifically? Okay. And to do with surveys, just to be clear?
Yes. From some of its surveys, other times it's post-conviction, it runs the gamut. I've done it federal cases, state cases, multiple states, including Idaho. But the way I learned was from Dr. Ed Bronson, who was kind of the pioneer in the field. He worked on cases like the Oklahoma City bombing case and a host of other prominent ones, the Boston Marathon, a bunch of them. So he was kind of my mentor in this area. And there's a 3-stage process. So the first phase is collecting the media coverage. Because really the question is initially, is there extensive coverage and is there prejudicial coverage? So I collect the coverage and assess the nature of that coverage. Does it include inflammatory language? Does it include inadmissible or misinformation? Now, just because it's not true does not mean people don't see it. And it does not mean that they don't develop opinions based on that information. So it's very important. In fact, some of that stuff is the most prejudicial stuff that there can possibly be. For example, if there is a prior conviction and then the conviction's thrown out, well, that's pretty prejudicial for the new trial. Not admissible, but very prejudicial. So I'm looking for information like that. I'm looking for references to prior records. Maybe there are victim impact statements where victims' families may be suggesting what the outcome should be. That could be prejudicial. How did the community respond? Are there candlelight vigils? Are there, GoFundMe efforts going on? The status of the victim, is it focusing on that? So there's a gambit of things that we look at. Sometimes there's political elements that are important in high-profile cases because it might be that a politician's involved. So it just depends on the case. So the first thing is assessing the nature of the publicity. Now, if there's not a lot of extensive pretrial publicity and it's not prejudicial, it stops there. And that's happened where there's coverage, but it's very superficial. It's very neutral. There's not a lot of detail. There's nothing particularly impactful. Maybe it's focused primarily on just the victim or something like that. However, there are other cases where there is extensive pretrial publicity, and then I would recommend phase 2, which is a community attitude survey. Because just because there's prejudicial coverage does not mean it had an impact on the jury pool. And that is the question that matters most. What impact has the prejudicial media coverage had on the jury pool? I don't really care if it's correct information, it came from social media, it came from the news. It had an impact on the jury pool. That's what matters, because they develop opinions and attitudes. And it doesn't make a difference if that fact's true or false. They still develop an opinion and an attitude about the defendant, about the evidence and perceptions of guilt. All of that is what I'm looking at. So I want to see if the media coverage has had an impact. And that's why we do a community attitude survey. And then depending on the results of the survey, there's not enough evidence there to suggest that anything is required. It could be remedial measures such as individual sequestered blood gear. Maybe that's appropriate in some cases, all the way to the extreme case where it might be a change of name.
I want to understand a little bit about the source of media you review to do your work. Can you tell me what you take a look at?
I always take a conservative.
Your Honor, I'm sorry, I need to object. This PowerPoint is being played for everybody with no foundation. It's not an exhibit. I think that's improper.
I think that's improper. Is not an
I'm trying to
objection.
listen to Dr. Edelman's testimony, and I keep seeing slides changing in front of me over here, and I don't think that's
It's a
appropriate.
demonstrative aid, Bill. Your
Well,
witnesses will do it too.
You've seen the slides.
I have.
You looked
But
at it.
everybody else here hasn't.
What I'm seeing here, though, is just an explanation of how he goes about in surveys.
Understand that. That's what his testimony is. But
Yeah.
we're getting this visual aid. There's no foundation for it, Judge.
Well,
It just seems.
well, hold on. I'm viewing him as an expert.
Yes, sir.
Okay? And he's explaining what he does. So I'm going
No
to,
problem with that. The PowerPoint's a problem. I don't have any problem with his testimony.
You don't have an objection.
all right.
I have a problem is not an
I'm sorry.
objection.
Yeah.
Frankly, I've never
But
seen
I'll
something like
overrule
this occur.
that objection. I mean, this is not necessarily factual. It's just an example of how he got to where he got.
That's his testimony, but the PowerPoint is different, Judge. I don't know why we're seeing the PowerPoint when we have his testimony.
You want to respond to that?
I do,
Okay.
Judge. This is a courtroom demonstrative aid that helps to track the testimony of Dr. Edelman. I can hand in my computer and let him advance the screens if that makes a big difference in it. This just helps explain his testimony.
Judge, we don't have a jury here. Let's just proceed.
Thank you, Sue. Go ahead.
Dr. Edelman, we were talking about where you get your information.
We were talking about the way.
Where you get your information. What media do you look at? I think that's where it was.
Yes. So I take a conservative approach to how I do it. I look at newspapers in the local coverage. So I'm interested in papers that have primary circulation in the venue. Case like this has been reported in many other newspapers, but I wouldn't, for example, look at a newspaper published in Dallas because I don't know if somebody in Latah County would be looking at a paper in Dallas. So I look at the local coverage. I try to look at like local television coverage to see what the community is likely exposed to.
While we're here, I want to ask you some questions about the non-dissemination order.
Okay.
That's been a hot topic and we've heard some of it again today. Are you aware that there's a non-dissemination order in this case?
Yes.
How did you become aware of it?
Well, the first time I became aware of it was when I was reading the newspaper coverage, because that was one of the topics of media coverage, was discussing the non-dissemination order and media's efforts to have it changed. So I was able to read it and follow it in that media coverage. So that's the first time I saw it.
And in January, did you receive an email from my office with the non-dissemination order?
I believe I did.
And you looked at a hard copy again recently?
Yes.
All right. Does that non-dissemination order change how you did your work?
I'm sorry, can you know?
Does the existence of the non-dissemination order change how you did your work?
No, it did not.
Have you worked in cases where there's a non-dissemination order at other times?
Many times.
Was the sole source of the information that you use contained in the media?
Was it came from the media? Sorry. Yes. Everything I used was widely disseminated through the media. Widely disseminated.
Did you find out where the media got the information?
Yes.
Good afternoon, folks. My name is Bill
Nice.
Thompson. I'm Thompson County
Nice.
prosecutor. And it's sad to be here, but happy to be here at the same time.
Oh my God, what a
Kohberger.
dunk.
Well, I'm gonna do my best to turn this up.
Oh,
Yeah, you can.
If I put the microphone up, is that better?
So yeah, but Christine, you don't have to things that are recorded.
Let me preface, there's a pending case now in court, and I in my office and the investigators have to live with the restrictions that our Supreme Court places on pretrial publicity. That said, I promise you we will share with you through the court process or otherwise whatever we are allowed to. I just appreciate your patience on that. The factual basis for the charges are summarized in what's called a probable cause affidavit that is on file with the court. According to the rules of the Idaho Supreme Court, that is sealed until Mr. Kohberger is physically back in Latah County and has been served with the Idaho arrest warrant. At that time, we expect that that affidavit will be available to you so you can share the true facts with all of your readers and your watchers and your listeners and all the people who are interested and really need to know what's going on. So please have patience with us on that. We hope to get that to you as soon as we can.
In that clip, you heard reference to the probable cause affidavit.
Yes,
And did you hear reference to sharing it with all your readers and watchers?
readers, watchers, and listeners, and anyone else who's interested.
Did your research tell you that the media took Mr. Thompson up on that offer to share this far and wide?
Yes,
Good afternoon, folks.
What did you see?
basically, the media took that document and then published the highlights and key findings in that document and added editorial commentary to that information. So let's be clear, they didn't just read the affidavit. There's editorial, there's debate, there's discussion, there's spin, all of it in news stories. And these stories, for example, this one has over 200, I'm sorry, I can't see it. Do you have a copy of the?
I do, Your Honor, I have a printed copy of his PowerPoint. If it would help him refresh his memory.
I just can't see it.
Sure, just go ahead.
Okay, thank you. So
yeah.
example, this one is on a local television station. On YouTube alone,
Too.
130,000 views and 224 comments. So people discussing. That's just one example of how this document was disseminated through the media in this county, just as Mr. Thompson suggested during his press conference.
And did you check another media source and see that it continued to be shared?
Yes, this is a second example. And you can see just from the heading, it says court records unsealed. And then they go through a timeline, including information from that affidavit, highlighting all the key findings about the car and other things that are widely reported and disseminated from that document. To Latah County, saturating the community with prejudicial details from that document, which was reported in the press conference to be truthful as well. 54,000 views, 176 comments on just one other video of a news clip on YouTube.
And based on your research, did the story or stories continue to be shared far and wide?
Yes,
Janelle Finch is joining.
cases received massive media coverage, saturating this county with prejudicial pretrial rules.
How about to social media?
It was also spread through social media, and people have talked about it on social media.
And do you know if misinformation and rumors ended up as a result of this information shared right from the start?
Yes, and the reason I looked at this and knew it was because in the media coverage, they discussed the spreading of rumors on social media. For example, a professor who was accused by a psychic of being responsible for this. Are there references to questioning the implication of people knew about the crime before it was reported to the police and so on? So there's been quite a bit of discussion, spread of rumors, misinformation, factual information all over social media, which you'd expect in small communities such as this.
Did your review of all of this information tell you as a professional, as an expert in your field, that a survey was necessary in Bryan Kohberger's case?
Yes, based off of the media coverage that I reviewed, which was over 200 plus articles, and the television coverage, I thought it was appropriate to move forward to see what impact, if any, this coverage has had on the community.
What kind of survey did you think would be appropriate?
We always use random digit dial telephone surveys in these cases.
Before you tell me a little bit more about that, I want to understand the history of this kind of survey. Is this something that you just made up all on your own?
No.
Where does this come from?
So these surveys have been done for decades. The first one I recall that followed a similar design focus on case-specific items was done in 1979. Constantini and King in 3 cases in Latah County, California. This approach was done, Dr. Ed Bronson, who I mentioned, my mentor, had been using it for decades, 40 years or more. Other experts in the field do it. John Walker, in the American Taliban case, they used a similar approach that was published as well. Used in Skilling, Boston Marathon. I've used it in countless cases, so hundreds of times, I would say.
Is there research that supports this process?
There is. One of the things we're looking at, so when you think about the survey, is the structure and how we test validity. So there's 40 plus years of social science literature on the impact of media coverage on juror and jury decision making. And one of the things it tells us, for example, is knowledge, or let's take a step back. People who regularly watch and listen to the news are more likely to know about the case. When they say know about the case, are more likely to have case-specific information from the media. So they test similar things like we did. Have you read, seen, or heard if ... And they assess how much knowledge does this person have, and then they correlate it with media consumption habits. And what you find is people that read the news regularly know more of these details than people who do not. And they find that the more information you have, the more likely you are to hold an opinion regarding the defendant's guilt or innocence. So those are some of the findings, and we craft the survey similar to the others because we want to test the validity of the survey. So if we know we should see these relationships, we should expect to see them in our survey. So we ask the same similar types of questions, and we look at those relationships to see if we see the same thing. That's one of the ways we test the validity of the survey.
Would this be considered a methodology in your field to do surveys in this certain format?
Yes, it's standard practice. We look at APOR, which is called the American Association of Public Opinion Research, American Society of Trial Consultants. They have professional code on how to conduct surveys, venue surveys. Those are the primary ones I look at. And again, I've taken course training during my program on how to craft surveys, how to write questions, all of that type of thing. I've done it hundreds of times, testified about it. So that's kind of the basis of how I craft this.
And I heard you mention standards and validity.
Mm-hmm.
Why are there standards? Why does that matter?
I'm sorry, why are there standards?
Yes.
Well, one is you want to make sure, as we learn more about research in human behavior, we learn more about what you should and shouldn't do. So for example, there's something called social desirability. People want to create a positive impression of themselves.
Mhm.
So when you ask questions, for example,
They'll never
can
say,
you
"I
be a
can be
fair
fair."
juror? Well, we all want to be fair people. So you're more likely to get a socially desirable response. The initial step on that was all the way back into voting. In California, there was a election for governor, I think it's Davis or something like that. And all of the polling suggested he was going to win. He was African-American, and he lost. And that was when they started looking at that. And they saw all these different impacts in terms of like race of the interviewer. All these things affect how people respond. People overestimate that they vote because you can look at voting records and it's inflated. People overestimate they have a library card and a million other things. So those are things like we look at when we craft the survey. We don't want to have social questions that lead to socially desirable responses, order effects, a host of other things.
In your survey, it looks like you have sections designed in your survey.
Mm-hmm.
Sorry, can you hear me? Okay.
Better with the microphone.
Okay, I'll try to stand closer over here. I want to understand this section, these sections.
Okay.
Why do you have sections in this survey?
Sections?
Yes.
Well, one is you don't want things to be jumping back and forth all over the place because it's harder to take a survey like that. You'll have more people drop off, confusion, potential order effects. So we try to organize the survey into sections. So all the key questions on one topic are together, and then the next section changes topics, so it's easy to follow.
What is the purpose of section 3, case awareness and prejudgment? Why is that in there?
So that's the meat of the survey. That's the most important section. So case awareness measures initially case recognition. We craft a recognition question based off of the media coverage. What are the things widely reported that are not overly prejudicial because you don't want to create an order that would stimulate a memory of, yes, I remember that case. So if widely reported A, B, and C facts that you read the coverage and you see this was mentioned 100 times, that's a widely reported fact. So we create case recognition question. Now, if somebody says, yes, I remember that case, I have read, seen, or heard about it, they're asked a prejudgment question next, guilt or innocence question. Then they're asked open-ended questions and then those case-specific items. Now, let's say someone does not remember the case based on the case recognition question. We give them one more fact to see if it'll stimulate a memory. Something neutral that might stimulate a memory. You usually get 1 to 2% more that recall the case from that. If that person recognizes the case from there, they are also asked that prejudgment question and they continue. If they do not recognize the case, they skip the rest of the survey and they're asked demographic questions about media consumption habits and demographics. The next step of the survey after the prejudgment question is an open-ended question. What have you read, seen, or heard about the case? There might be a few others we add based off of these things we might find in the media coverage. And then they continue on to those case-specific items that we've been talking about. Have you read, seen, or heard if so and so?
I want to make sure I understand this and that this is clear for everybody. Those 9 questions that have been the problem last week and this week, if you have somebody who says, no, I don't know that case, do you ask them those 9 questions?
No, they skip to the demographic questions.
Tell me, what are the demographic questions, just to be sure?
If somebody doesn't recognize the case, they immediately go to questions, for example, how often do you read the newspaper? Every day, several times a week, rarely, never, something like that. Then they're asked how often they follow the local news, and then they'll ask a few demographic questions like age, gender, race, ethnicity.
So if somebody doesn't remember the case, you don't infuse information or do any of the things that were brought out last week.
No.
I have on the screen in front of me some of the read, seen, or heard questions.
Yes.
What are these? You don't have to read them all, just tell me what they are.
These are 9 items, which we always use. Have you read, seen, or heard if? And these are items taken from the media coverage that were widely reported. And let me be clear, widely reported hundreds and thousands of times, and potentially prejudicial items. Because neutral run-of-the-mill media coverage is often not grounds for a change of venue. So if somebody knew there were 4 victims, that's not particularly prejudicial, is it? That's a pretty benign fact. But if somebody knows, for example, about a prior conviction that's not admissible, that's very prejudicial. And it might be correlated with prejudgment. And I would like to know that, because if it's widely prejudicial and everybody knows about it, and it's correlated with prejudgment, that would likely have an impact on my recommendations, because that's the type of pretrial publicity that has been recognized by the Supreme Court, I'm sure the state court here, that is most concerning.
So these kinds of questions, these case-specific questions, you do this in all the surveys that you do.
Yes.
And in this case, these 9 questions came straight out of the media.
Absolutely. And again, widely reported throughout the media, thousands of times.
Now, just to be clear, you gave an example of information that might be widely reported that's highly prejudicial that you would use in a survey. You haven't talked about Bryan Kohberger's survey yet, have you? You haven't told us the 9 questions.
I have not.
Okay. And we'll get there, but I want to talk about a little bit more about the history of this survey. You told us it had been used for decades. And I think you told us a little bit about some of the other really high profile cases where this survey format, the survey method that's been widely accepted was used. Are some of these cases your cases that you've done these surveys in on this list?
Yes, I used these types of questions in the George Floyd case for Alexander King, who was one of the defendants. There was also a gag order or non-dissemination order in that case. The Parkland shooting case in Florida, there was a non-dissemination order in that case. Used there as well. Used it in the Pittsburgh synagogue shooting case in Pittsburgh. State of Idaho v. Jonathan Renfro, which was here. State of Idaho v. Gilberto Rodriguez, also used it there. And many others. I've used it 100 times. Dr. Bronson used it more than me because he was doing it even longer than I have. Other experts in the field do it. This is the standard practice.
Standard in your field.
Yes.
And are these surveys, doing a survey like this, is this just criminal defendants that ask you to do these surveys or that have any interest in doing these surveys, or is it other people too?
Other people use the same process as well, including the prosecution and the government.
I think you provided an example in your PowerPoint of the government using this survey process in a case that you worked on.
Yes, this was the Jason Van Dyke case in Chicago. He had been charged with shooting and killing Laquan McDonald. It was like 17 shots was like the famous saying. It was a very significant case, interracial crime, widely reported on. And the government also did their own survey to see if there was any potential bias and followed the same exact process and used case-specific media items. And once again, there was a non-dissemination order in that case.
Earlier, you talked a little bit about validity being one of the standards.
Yes.
Tell me how you measure validity in one of these surveys.
Sure. So this is from the professional code from the American Society of Trial Consultants. As I mentioned, we want to look at things like consistency. So we want to, for example, the research tells us the more case or media items you know, you develop knowledge. And the more you know, the more likely you are to exhibit bias. So I want to test that in the survey. That's one of the reasons why I include those case-specific items. I also want to compare what people or that item to prejudgment. So the more people know, are they more likely to prejudge? How about case-specific media items? Is there specific prejudicial items in the media that are particularly concerning? Maybe I'm going to go back to my prior conviction example. If there was a conviction, so I've had this happen in a case, and then years later, that conviction was thrown out and there's a new trial. Well, that's extremely prejudicial if people know about the prior jury verdict. So I want to know, what percentage of people know that detail? And is that related to prejudgment? And most importantly, when you ask the question, have you read, seen, or heard about the case, the open-ended question, do people report it? Because if they don't, and they do know it, well, that's very concerning. And that's the type of problem we run into in voir dire.
Sounds like that's one of the reasons you have case-specific questions in there.
That's one of the reasons, absolutely.
You heard talk last week, and then you've heard it again today about, can't you just change this survey and take those case-specific questions out and then do the survey? Can you do that?
I would not do that, no.
Can you explain why not?
Because this is based off of 15 years of doing this. I know for certain, and there's research on it as well, that when you ask people an open-ended question, what have you read, seen, or heard about the case? They have a difficult time recalling everything from memory. That's a recall question. The cognitive effort required to recall everything from memory that you know is very challenging versus recognition, which is a much lower cognitive load. Have you read, seen, or heard if? Oh, now I can search my memory. Yes, I know that fact. If I asked you, tell me everything you know about the movie Star Wars, you would tell me a whole bunch of interesting things about Chewbacca and Ewoks, and maybe a bunch of other stuff. But I am very confident that you would miss things. You would not tell me every single detail from memory you know about that movie. And then I would ask you something like, did you know that Darth Vader was Luke Skywalker's father? And you'd probably say, yeah, of course, I knew that. But you didn't mention it in the recall question. There's a mountain of research on this. Usually what they do is they have people read like a paragraph or a story, and they ask them, write down everything you recall from what you just read. And then they do a different type of quiz. Did you read that the truck was red? Did you read that there was an ambulance? Oh yeah, of course. And they check that too. And what it shows is recognition rates, the ability to recall information when asked a closed-ended question is much higher than when you ask an open-ended question. So getting back to your comment or question, if I only ask, what do you know about this case? I know for a fact you'll get things like, well, I remember when it happened. There were 4 victims. There was a knife. I remember there's a delay. I just saw it in the media. Those are the things that people say. They've said it in this survey. They've said it in the 100 surveys I've done prior. They've said it in voir dire when I look at transcripts. That's what you see. But when you ask those closed-ended questions, you discover that they know quite a bit more. And that's what I'm trying to look at. I need to know,
Jar Jar
what do
Binks.
people actually know? And is there information, prejudicial details that they don't mention that they do know when you ask the open-ended question?
And those details, the closed questions, the have you read, seen, or heard questions, are they important to determine if there's bias, that media coverage has created a prejudicial effect, and that there's bias?
Absolutely. If 80% of people are able to recognize a prejudicial detail, and I keep making up because I don't want to upset anyone here, like a prior conviction, if 80% know that detail, but only 3% mention it in the question, what have you read, seen, or heard about the case? That's a major problem. I need to know that because it's an extremely prejudicial fact. Things spread on social media, whether they're true or not, they still impact the jury. Very prejudicial. I need to know if they know that. And I know for a fact in this case that, for example, I'm not going to mention the detail, but for one of them, only 3% of people in this survey mentioned the detail when asked, what have you read, seen, or heard about this case? It was something spread on social media. But when you asked, have you read, seen, or heard of X, Y, and Z, 45% knew that fact. And that fact happened to be significantly related to prejudgment.
Yeah,
People who knew it,
stalking the
80%
victims
of
or
them
social
think
media
the
connections.
defendant is guilty compared to 57% who don't know the detail. So those are important findings. If I don't include those questions, I can't do any of those analyses. It makes it look like there's not that much of a problem here. People don't seem to know anything. They just say they remember reading it in the paper. I guess we don't have to move the case because they don't seem to know much. And that is misleading, inaccurate, and I would not do that.
Oh,
Have you
good
had
stuff.
a unique opportunity to kind of actually watch this in real time to see how it works?
I have.
Can you tell us about that?
Yes.
How did you get this unique opportunity first?
So I worked on a case that was called John Fight. This was a Catholic priest in Hidalgo County in Texas who had been charged with murdering a beauty queen. Now, the crime had happened in like the 1950s, and the trial happened in like 2018 or something like that. So all the witnesses were gone, and the defendant was obviously much older. But it was a case that was just weaved into the fabric of the community. It was so shocking. And during the hearing, after doing a survey, one of the things we did is we brought in community residents and did like a mock voir dire to prove this point, to demonstrate. And there was a bunch of things in that case that were particularly prejudicial. So we asked people, tell us what you've read, seen, or heard about the case. And they would tell us, oh, in college, I learned about this case. And I know A, B, and C. And we say, is that everything you remember? And they said, for example, here, I believe so. That's what this person said. Search their memory. Let's see. I believe so. That's it. And then we asked those case-specific questions that you clearly could never ask in voir dire because you'd be poisoning the well. And we asked, for example, did you know that John Fight gave a confession to a priest, confessed to the crime? Oh, yeah, I knew that. And once she said that, it stimulated her memory. Actually, he confessed twice. So now she knows that. The fact that she did not mention in the open-ended question, extremely prejudicial. The Supreme Court has recognized confessions to be very prejudicial for Doe v. Louisiana and a bunch of others. And she knows that. And then we ask kind of again, is that everything you know? And she says yes. And then we give her another one. Did you know that he was involved in another case? He had actually been charged with attacking a woman in a different church. Oh, yeah. Yes, I do remember that. Once again, she knows a detail that she didn't mention. And right for saying, okay, and you didn't say that a few minutes ago, did you? No,
nothing else.
That's the second one. And then we asked, have you refreshed your memory? Are there any other facts that you have read, seen, or heard that you haven't told the court? She's, I don't believe so. So it seems like that's all she knows. Then we tried again, and we mentioned that he had been transferred to another monastery. The Catholic Church was moving him around. And she knows that too. Oh, yeah, I did do that. And we tried again. Did you know that local law enforcement were participating in a cover-up. That was part of the story. Yep, she knows that too. So this was an example of the difference between asking the open-ended question that you can ask in voir dire, what do you know about this case? What have you heard about this case? And you get an answer. Sometimes people say, I just recall when it happened. Sometimes you get more detail. But when you start asking those closed-ended questions, you uncover that actually they know quite a bit more. And that is the key point in a high-profile case. In the general case, it doesn't matter because there's no case-specific information. What we know is that specific attitudes predict behavior much more than general attitudes. So in a community like this, it's been saturated with media coverage that's prejudicial. We want to know what case-specific details they know, because that goes to bias, and are we able to ferret out that bias in jury selection? And that's why we include those questions.
What great examples.
I want to talk about Bryan Kohberger's case for just a minute.
Your Honor, again, I'm going to register the objection. This is going to deal with the actual issue of change of venue. It's premature. The state has not been afforded the opportunity to analyze much less respond to it. So to the extent that the court wishes to allow this to continue, I just simply ask you to give it that reduced amount of weight, because the state is not in a position to respond to any of this.
Oh, it's not fun when you don't have a chance to respond,
You have an
Bill, is it?
opportunity to respond to any of this.
You had a week and had a day.
Not today, Judge.
I'm sorry. Hold on.
Yes,
I'm
sir.
not going to make a decision today.
Yes, sir.
I'm getting information,
Yes, sir.
and then I'm going to consider what you're going to provide, and then I'm going to make a decision.
My point again, Your Honor, is this goes to the issue of a change of venue, not whether or not the non-disclosure order was violated and what we should do about that. Two separate issues. The state is not prepared and will not be prepared to address a change of venue issue until an appropriate motion with supporting documentation and evidence provided, and we have a chance to respond to that, which I understand we'll be doing between now and sometime next month.
Exactly.
Thank you.
Go ahead.
Okay.
Thank you. Dr. Edelman,
I guess we'll let him feel like he won.
you haven't finished analyzing the data in Mr. Kohberger's case, have you?
No, the only thing I looked at was supposed to be on the question at hand, which is about these case-specific items, why they're in the survey, and which goes to whether we can continue the survey without them. That's the only thing I looked at, was addressing that specific question.
I'm not going to ask you what your opinion on change of venue is today.
I don't have one. Well, I do, but I'm not done analyzing the data.
Senate, I want you to be informed before we get there. So I do want to talk, though, about Bryan Kohberger's case, and if you've been able to determine if the survey was valid.
Yes, absolutely.
And how did you determine that the survey is valid?
Well, one of the things, as I mentioned, is looking at the social science research, and do we find similar findings? And we did. So we also look, for example, do we have like acquiescence bias? What that means is people are just saying yes to everything. So on those case-specific media items, one of the things you do is you include items that didn't receive as much media attention. That way, you want to make sure, and what you expect to see are items that get a lot of media attention. Everybody knows about them. So you see really high recognition rates, 80%, 90%, 60%. And then the items that didn't get as much attention, they're lower, 40% or less. So we want to see if there's variance across the questions, and we see that as well.
Does it help to do the recall questions and the recognition questions to understand whether you have a valid survey? Is that what you're telling me?
Yeah, well, as I mentioned, those are the case-specific questions. Yeah, those media items. So we test validity by, are those correlated with prejudgment? Are they correlated with media consumption? So people who read more of the media, do they know more of these details than people who don't? The more details you know, are you more likely to be biased? All that stuff. But also, again, like I said, is you want to check to make sure there's variance across those media items, because you want to make sure people aren't just saying yes to everything.
You talked early on about how if somebody doesn't recognize the case, you stop and you don't ask these case-specific media generated items in your question.
Correct. And remember, these media items also come after the open-ended, what have you seen or heard about the case?
Do you know how many people did not know about Bryan Kohberger's case in this survey? The percentage?
I believe it was like 3 to 4%.
Yeah, sounds about right.
And so that percentage of people didn't get the case specific questions. Is that fair?
The people who did not know about the case, the very few, did not get the case specific questions.
I want to talk about the open-ended questions and then the have you read, seen, or heard questions. So on the open-ended questions, when you say, what do you know about this case? Tell me everything. Do you know about how many things people remember?
Yes, so one of the things we do is we read every one and we track how many details they mentioned. And then we compare those, what did they say, to how many case-specific items they later recognized. So for example, if somebody said, I know 4 people were killed and they found the guy, I would identify like 2 facts, 2 details, for example. And then I would look at those case-specific items later and how many of those items did he mention in the open? And that scenario would be 0. But if he knew 6 of them, that would tell me that he knew 6 details that he failed to recognize. Versus somebody might have known all those details and mentioned all of them in their open, then it would be 0. They reported everything they knew, and they mentioned later on that they knew those items. So I look at that.
You're checking what they say they know in the general open question, and then see if they hit some of the specific questions, and then measuring how many more they actually know when you get to the have you read, seen, or heard question.
And then I compare. And that kind of goes to my John Fight story. I'm looking to see if that is a problem.
What did you find in this case?
I found that 96% of survey respondents knew at least one additional media item that they failed to mention in the open-ended question. On average, people reported 1.6 details when asked the question, what have you read, seen, or heard about the case? However, on average, they later recognized 6 out of the 9 media items, and I believe it's something like 72% knew, I want to say 5 or more.
Oof.
Now, in this situation, did you find out people had a lot of knowledge that wasn't the specific case-related questions? They would rattle off, I know these things, several things.
Yeah, so what I found was on average, people knew at 4.9 additional items that they failed to mention in the open. What does that mean? That means they knew approximately 5 of the media items that I tested later that they did not mention in the open-ended. 5 on average out of 9 they knew, although they didn't mention it. And these are examples. So somebody wrote just what has been on the TV and the papers. That's the common thing you get when you only ask the open-ended question. But that person knew all 9 of the media items we tested.
Oof.
Someone else mentioned a detail. The kids were murdered and they tracked them down. Well, you actually know 6 out of the 9 media items that we tested. Nothing lately knows 7 out of the 9 media items tested. And it goes on and on. That is a very common finding. I find it in almost every survey I do. Between 92 and 96% is the norm. What I see in terms of knowing more detail than they report. And it usually, interestingly, the average is usually around 3 extra media items that they failed to mention. In this case, it was 4.9, so it was higher.
Do you have a way within the survey to correlate prejudicial coverage or bias for guilt with the amount of specific details recognized?
Yes, because I asked those case-specific questions. If I didn't, I would not be able to. Because as you saw, people say things like, haven't seen anything lately. Well, that doesn't really do much for me. I can't analyze that. I can't do anything for that. I don't ask those case-specific items. I can't test the validity of the survey. I can't test to see how case-specific knowledge impacts prejudgment. I can't test to see if there's one particular item that's highly prejudicial that we should be worried about, that should, that's inadmissible. What percentage knows that detail? All of those things are required to do this correct.
And how do you know that there's prejudgment in a case? What questions do you ask, and when do you ask them to know that there's prejudgment or bias in a case?
Well, after the case recognition question, they're asked, based off of what you've read, seen, or heard about this case, do you believe the defendant's guilty of whatever the crime is? And it's on a scale of like definitely guilty to definitely not guilty. So that's a prejudgment question. I have a second follow-up question, which was actually developed from a judge that I thought was really effective. And the question was, would the defendant have a difficult time convincing you that he's not guilty? So it's a presumption of guilt as opposed to a presumption of innocence. This was in Tennessee. It was a high-profile case, and similarly, people would report a lot of detail, and then they'd say, "I think he's guilty," and then that's what, can you be fair and impartial? And they go, "Yeah, I think I could be fair. I can try. I think I could do it." And then the court would ask, "Well, would the defendant have a difficult time convincing you that he's not guilty?" And they'd say, "Oh yeah, definitely. It could be hard to change my mind." So I use that question because I thought it was really effective, and it happens to correlate much better than the set-aside question with prejudgment and a host of other things.
So do you ask those questions before you say, have you read, seen, or heard these particular?
Absolutely. If you didn't, you'd be creating order. So you have to do that.
Will you say that again? You'd be creating what?
Order effects. If I put in like a recognition question, some detail that's extraordinarily prejudicial, I'll go back to my prior conviction thing for the same crime. And then you say, "Oh, do you think he's guilty?" Well, you just told me a jury convicted him. Of course I think he's guilty. So if you included all those 9 items, and then you ask somebody, "Do you think he's guilty?" You just gave them all this information that's prejudicial. So yes, that would be an order. So we would never do that.
So you ask them well ahead of case-specific questions. They have to recognize the case. They have to agree, I know of this case.
I have no.
And then you ask if they already have an idea of what they think of whether Mr. Kohberger is guilty or not in our case.
Correct.
And then you have the case recognition, and you can measure the bias or the prejudicial effect of the media with the incidence of those questions.
What I look at is the prejudgment question, right? That's on a scale, it's a Likert scale.
So they already think he's guilty
There's a relationship
before any of
between
this
the number of details
information is
somebody knows
forced
and
fed
the
to
strength of
them.
opinion. Definitely guilty. For example, if you know a lot of detail, I can look at case-specific items, media items. If you knew about X, is that correlated with prejudgment or bias? Is there something that, and so on and on. So that's how we look at the relationship between prejudgment and these different factors.
Were you able to determine if case knowledge was impacting bias in Bryan Kohberger's case?
Yes. So because we asked these questions, what we found is that one, like I said, very high recognition rate. So 79% of respondents knew at least 5 of these items. So the idea that we're undermining his due process rights, everybody knows all this stuff. Very high rates. 82% of respondents who recognized 7 of these items or more reported that he's guilty, compared to if they only knew 2 or fewer, only 29% thought he was guilty. And the average was 6.2. So the average number of these details people already know, 6.2.
Given specific case-related bits of information, these 9 have you read, seen, or heard questions, does recognizing one of those questions, if that's oh yeah, I know that one, does that change the incidence of bias, or does that relate to I've already prejudged this case?
It does. And what's really interesting is kind of going back to the open-ended question. So again, I won't mention the detail, but there's one that was widely reported. It's in that affidavit. And 81% of survey respondents knew that specific detail. 81% when we asked, what have you read, seen, or heard about this case? However, on the previous question, what have you read, seen, or heard about this case, the open-ended, only 8% reported it. 8% report it when you ask the open-ended question. 81% actually know the detail when you ask a recognition question. That's significant, and I can only do that analysis because we asked those questions. And 72% of people who knew that detail reported that he is guilty, compared to just 47% who don't know the detail. So that's the kind of analysis we look at. What do these case-specific items look like? If you know this media item, is it correlated with guilt? What percentage of people know that media item? How many people mention it in the oath? Is it consistent, or is it perfect overlap, or nobody talks about it, but they all know it? In another one, only 3%, I think it was 3% 3% mentioned a specific detail that was on social media, widely reported in the news, not factually accurate, a misrepresentation of the truth.
Yes, thank you. for putting that out
45%
there.
knew it in the survey. Only 3% reported it in the open-ended comment. And it was extraordinarily prejudicial where if you did know it, 81% of survey respondents, if they knew that detail, indicated that the defendant was guilty. 81%, half the sample knew about it, but only 3% mentioned it when I asked the open-ended question. So again, if I didn't ask those questions, and the only thing I asked was the open-ended question, it would appear that people don't know a lot of prejudicial detail because they don't mention the detail when you ask that question. And that is, from my experience, doing post-conviction work, reading voir dire transcripts, coding transcripts, doing hundreds of jury selections, being involved in these cases, coding juror questionnaires. This is the phenomenon that we see all the time. It's nothing new. And the only way to look at it is by doing the survey this way.
Oh, Grant County, Washington case.
Before I ask the
County is-
question about courts relying on surveys
Oh, the
to
juries, I can
make
tell.
decisions, using these surveys to make decisions to change venue. When you talk about things that are in the media that aren't true or might not come in, we've heard a lot about that today. Are you telling me that that's still going to be in my courtroom? Things that aren't true that don't get brought out in trial, those are still going to be in the jurors' minds?
Absolutely. And again, there's social science research on this, looking at the impact of inadmissible content, the effectiveness of judicial instructions, and how it impacts jury decision making. Just because you say it's not evidence doesn't mean it's not prejudicial. Just if I know it, it impacts how I view the defendant. It serves as a filter through how I process information. I might expect to hear that information when I can assume that I will, so it has an impact. One interesting study looked at jurors' ability or participants' ability to recall the source of information. And what they found is after a few days after a trial, people couldn't recall what information they had learned from the media and what information they recalled and learned from the trial. So they assumed stuff in the media came out in trial. The idea that I can cognitively say, okay, I know this prejudicial detail, and I'm going to put it in a box in my mind and never think about it and process everything, and it's never going to affect me. It's just, there's nothing to support that.
No.
It's kind of in our everyday lives. That's what our brains
So hubris.
think about what's going on today with Trump and Biden and all that. Everybody has strong opinions. The idea that, oh, yeah, well, it's not legitimate or that fact is wrong, it's misinformation, so it won't affect me. There's nothing to support that. There's even research that shows you have people, they read a passage, that they write something supporting a position that was in the passage, and then you tell them that information is not true. It's called belief perseverance or belief persistence. And what they find is even when you tell them that fact is not true, they still have a difficult time not believing it. And it still impacts their views. They still defend it, even then. So there's a host of research on this. The idea that we should only test things that are factually accurate and assume that the other stuff isn't prejudicial is just ridiculous.
Yeah, it is ridiculous.
So a massive amount of prejudicial media coverage is a factor that has to be considered in a case with this kind of coverage. Is that right?
Yes.
I want to know, though, from your experience, have you done a survey like this that contained these 9 case-specific questions where a judge decided to change venue?
Yes.
Will you tell us about that?
Yes. So in Nichols, there was a case in Washington, and this is kind of what I was referring to. So it was a defendant who had been convicted in 2012 for murder, Grant County, Washington. Later, it was a high-profile case, and then later the conviction was thrown out. It had something to do with jury instructions or something like that, and there was going to be a new trial. And quite a bit of time had gone by, like a decade. So we did a survey because that fact, knowing that detail, would be highly prejudicial. So what we found was 42% of survey respondents had read, seen, or heard about the prior conviction when we asked that case-specific media item. However, when we asked the open-ended question, what have you read, seen, or heard about the case? Only 12% mentioned it. So 12% mentioned it when you ask the open-ended question you use in voir dire, but over 42% knew about it. Now, you could never ask a juror, well, did you know a jury convicted him of murder if he didn't mention it because you're poisoning the well? And the court agreed. and was worried about the effectiveness of voir dire as a remedy in that situation and granted a change of venue.
Have you had the opportunity to pay attention to any prejudicial media coverage since the hearing last week?
I have.
What is that coverage?
Well,
Man,
it
look,
created
hot water.
misrepresentation, false narrative that myself specifically, had done something wrong to poison the well, taint the jury pool, and using language like that. That became part of the narrative. I saw it on Reddit, on social media, in the news, that once again, going into this idea of what the story was, that the defense had done something wrong, debate about whether it was part of their tactic to delay, get him off on a technicality and so on. And again, what I did, just want to be clear, is the standard practice in the industry, done hundreds of times in high profile cases throughout this country. There's nothing I did to contaminate the jury pool. Everything I included was widely disseminated by the media in this county hundreds of times, if not more. And most of it came directly from an affidavit that the government released in a press conference and encouraged everyone to report.
Boom.
Did I tell you what questions to ask?
You did not.
Would you take my advice if I told you what questions to ask?
I would not. And I'll tell you why is, as I mentioned, my role is to be an objective expert to provide the court with information so the court can make a decision on if any remedial measures are necessary. I don't care what questions you want in the survey, and I don't care what questions the government wants in the survey. What I want to do is conduct a valid survey that's objective, reliable, and provides meaningful information that can be used by the court.
Do you believe comparative surveys in other counties would provide the court with more information about what to do when we get to change a venue hearing?
I do.
Why?
Because this case has received a lot of media attention across the state. It's a national case. And depending on what the results are of the survey, I'm assuming if we find that there's grounds for a change of venue here, if that's a recommendation, the response will be, well, there's nowhere else to move it. Everybody's been cut saturated with pretrial publicity, so there's no need to change it. The point of the comparison survey is to address that question. Is there anywhere in the state where you could move it? Maybe there's not. I don't know. But that's the only way to find out. And you have to conduct the survey in the same manner. I don't know if I just ask people what they know about the case and you get general, I just recall when it happened, but you have the same guilt rate.
Same problem.
Do they know inadmissible details? Do they know about things from that affidavit? Do they have a lot of case specific knowledge, or is it just a general awareness of the case? Did they drive by the house where the crime occurred? All these things that make this county unique that you want to test for in other communities. So it's not just a question of general awareness. I need to know what case specific information they have, what misinformation they have, what media items they've been exposed to. Do they have as much case detail and knowledge as they do here? All of those things. So that's why I would suggest it's important. Without that, the only thing I can do would be to collect the media coverage and assess, for example, like, are there fewer articles published in Bonneville County or Ada County compared to here? That's all we have. I wouldn't conduct a survey that I know is going to lead to misleading information. I'm not going to do that.
How is Bill going to
To
cross-examine
change
this
the
guy?
survey, would that go against the methodology that you use?
Yes, if I change the survey and I don't include those items, I can't test. Well, do people know a lot of case specific information that was widely reported? Are those specific items related to bias? Which items do they know? Do they know the ones that were all over social media or not? Like, that's the whole point of asking those questions. What you'll get is, well, I don't know much, but I saw it when it first happened. I remember reading about it a while ago, but haven't seen anything lately. I know the defendant was, arrested or whatever, or things like, oh, I followed it close. Okay, great, followed it closely. Does that mean they know a lot? I don't know. I can't assess just from someone said, I read the news or I followed it quite a bit. That doesn't tell you anything. That's not meaningful information. So yes, you need to conduct it in the same fashion.
Last week, your professionalism, your work, your reputation was impugned.
I believe it was, yes.
if you're allowed, if the court says, okay, go ahead and finish these surveys, I want comparative county information, are you willing to still work with us?
If we do it correctly, if the idea is we want you to conduct a leading bias survey to get results that we want, then no, I'm not going to do something
Oh,
that
man.
undermines my credibility, my objectivity, or do it in any way that's not consistent with the procedures and standards that have been used.
Thank you. I don't have any other questions.
Damn,
Dr.
that's
Edelman,
quite
the
close.
state, right?
Mr. Thompson, thank you.
I maybe we'll start going backwards here, or from the back to the front topic. I'm sorry if you're feeling hurt about us raising this issue. I see you were almost breaking down a few minutes ago when we were talking about slide number 33, slide number 31. That's not the intent, and it's certainly, I'm surprised to see that reaction from an experienced expert such as yourself. So I apologize for that.
I accept your apology, but the idea of after working really hard 15 years to develop a credible reputation and being told watching on a Zoom that I am tainting the jury pool and poisoning the jury pool and contaminating the jury pool by doing what's required and standard, I'm not crying. I'm angry. Okay. And yes, it doesn't.
And please go ahead and be as angry as you like as you continue your work for the defense in this
I
case.
think he will do that, Bill.
It is a fact, though, that you don't know of the 400 citizens that were questioned on this survey. You don't know which ones of them did not already previously know any of the fact-specific representations in your questions. Isn't that true?
I do know because they answered yes or no to the question.
No. Oh, well, okay. Before you asked the question, you didn't know that. Isn't that correct?
That's correct.
And so somebody who hadn't heard the representation in that one slide that you acknowledged was false. Let's see.
What are
You
you
acknowledged
asking?
false that Mr. Kohberger allegedly stalked one of the victims. That's false. You know that to be false.
Which one?
That Mr. Kohberger allegedly stalked one of the victims.
Yes, I was trying not to say that because.
But you knew that was false.
I did.
Yes. And so you have now, for anybody who had never heard that before, that question is now planted into them, unqualified representation that Mr. Kohberger stalked one of the witnesses, and that's false.
That's false. Yes.
Yes. Okay. Thank you. Thank you.
Okay. All right.
Okay, and
just to follow up on that, early on in your testimony, you testified, I want to make sure that we heard this correctly, that inadmissible or false information can be the most prejudicial information.
It can be.
Yes. And your surveyors put that false information into the minds of people who were asked that question who may not have previously heard it. Correct.
Correct. Relative
Thank
to
you.
the media.
Thank you.
It's mentioned it hundreds and thousands of times.
And just make sure we're clear too, around the same time in your testimony, I believe you testified that you don't care if the information that you put in your specific questions to the people being surveyed is correct. That you said that, didn't you?
Right. I don't know what you mean by correct.
True or false?
I care about whether or not it's proliferated by the media.
You don't care if it's true.
No, I don't. I
No.
don't care about is it prejudicial.
So it's okay to taint people who had never heard that information before for the end result of identifying others who have and might have bias. Is that a fair statement?
I'm gonna
No,
object to the
it's not.
questions. He's
He can answer the question.
badgering.
Wait.
Let me finish
Hold on.
my objection.
Yeah, it's an objection.
He's badgering the witness. He's misstating his testimony, and I object.
The witness testified he didn't care if the information was correct, Judge.
Yeah, overruled. So,
May I?
so just
No, that's okay.
one person can talk at a time. And, let's take down the tone a little bit.
Yes, sir.
Do you know how to ask a question without yelling and looking like an angry grape? Because it seems like he doesn't.
Okay, just so we're clear, the questions, fact-specific questions were propounded to people who were taking the survey. Did not, after asking the question even, qualify the false facts as saying this may or may not be true, or this is actually a false fact. The survey didn't tell them that what they might have heard was false.
First of all, I don't call them facts because they're media items. And then second of all, that would be ridiculous. And no, I wouldn't do that in a survey. Are you suggesting I follow up? Have you read, seen, or heard if he's stalked? But oh, by the way, if you know that, let me tell you, it's not true.
Exactly. That's exactly what I'm suggesting, because isn't that exactly what happens in the voir dire process?
No.
Absolutely it does.
Your Honor, I'm gonna object argumentative.
Yeah, it is.
Okay,
argumentative.
yeah, you don't get to testify exactly about that, so I'll sustain.
Dr. Ellman, have you participated as an attorney in voir dire in Idaho under Idaho laws?
Have I what?
Have you participated as an attorney in voir dire, conducted voir dire, in a criminal case in
Not
Idaho?
for dear Bill. This isn't the panel, and it's a year before trial.
And just to be clear, because in two places, at the beginning and at the end of your testimony and your PowerPoint, this PowerPoint, you created that, Ms. Taylor. So you adopt what the contents of the PowerPoint is.
Yes.
Okay, thank you. Just to be clear, not every fact-specific question that your surveyors asked came directly from the probable cause affidavit. Isn't that true?
Well, to be clear, they're not facts. They're media items.
They're representations of
Your Honor,
fact
I'm gonna object.
in the PC
And
Wait a
affidavit.
minute, hold on.
I'm objecting and ask that he allow Dr. Edelman to complete his answer before he jumps back in.
They're simple yes or no questions.
What was your question?
Yeah. Let's just say, one at a time, okay, listen to him answer, and we'll
Get a real preview of how
Through
this trial is going to
at some
go.
point.
Thank you. So, Dr. Edelman, isn't it true that there are among the 9 fact-specific questions, that's my characterization of the 9 questions, we know which ones we're talking about. Not all of the representations in those questions came from the probable cause affidavit, isn't that true?
That is true.
And are you aware that under Idaho law, probable cause affidavits in criminal cases become open to the public by operation of court rule once person is arrested and appears in court?
I'm sure that's true. I'm just not used to having press conferences to tell the media to disseminate the information far and wide.
Oh, so let's talk about that. That press conference
Yeah,
was
let's talk
made
about it.
prior to Mr. Kohberger's appearance, prior to the release of the affidavit. And the press conference only referred the media to what would be part of the official court record. Isn't that true?
I don't know. All I heard was this is going to be released. I encourage you to tell your listeners and viewers and anybody who's interested in the truth.
By going to the court record and looking at the probable cause affidavit.
About
Isn't
the
that true?
allegation.
I recall you saying, I want you to go to the court record and look at the probable cause affidavit. And what it did was
You're splitting hairs and
media.
now, doctor. That's fine. I don't have any other questions.
Okay.
Thank you. So, okay, go ahead.
Thank you. I want to start with the probable cause affidavit, and I think you testified that that probable cause affidavit was spread far and wide in the media over and over again. Do you recall that?
Let me be clear. It wasn't the probable cause affidavit that was spread far and wide. It was details taken from it, put in media stories with editorial comments back and forth in the context of news stories. It wasn't, here's a document from the government that was in the court record. Let me read it to you. That's not how it works. It's media
We
coverage.
only do that on Law
That's
2.
how it's reported. Taken out of it.
They don't do
DNA
that
stuff,
on News
all the
Nation.
other stuff. Reported within the context of a news story.
So the news takes this document, takes things from it and runs with it, spins with it, changes it, talks about it, and sends it out.
Yes.
Sometimes, do you think the media gets it wrong after they read something?
Sorry, what?
Does the media ever get it wrong after they read something?
Yes.
And do those stories have any less prejudice on somebody's, on the reader of that media, whether they're wrong or not?
No. And going back to, I don't care if it's true or not, my focus is to assess whether or not media coverage is prejudicial, and whether or not it's led to opinions. It doesn't matter if it's true or not. You don't say, well, I won't test all this prejudicial stuff in the media because it's not true, so I won't include it in the survey, and I'll just assume that it had no impact on people. I find it convenient to be able to disseminate a whole bunch of prejudicial media coverage, saturate the community, and then say, oh, you have no right to test the impact of that information on the jury pool. So it's wonderful that you get the benefit of generating all the bias by releasing it to the media and then saying, no, you're constrained defense. You're not allowed to ask questions about it because that stuff's not true. Or you might have told one person in the jury pool a detail they didn't know. Oh, they knew the other 7 details that are highly prejudicial, but it was that one that shifted everything, and that's going to lead to the contamination. Not the thousands of newspaper stories, not the media coverage, not the stuff on social media. It was because the survey vendor called 400 people and asked a question that one person or 2 people in that panel or whatever it was in that 400 may not have known that one detail. They knew everything else. They're already biased, but it was because they learned that one detail, that's what shifted the scales. That to me is just ridiculous.
And if somebody said, I don't know anything about this case, did you stop?
Yes.
Mr. Thompson was talking to you about the difference between, in the survey, between closed questions and what can happen in voir dire.
Yes.
You're not an attorney, is that correct?
Correct.
Well, what's the difference between what you can do in a survey and what you can do in voir dire as far as your expertise?
Well, again, I sit in jury selections. I've done hundreds of them. I've done research on voir dire transcripts. I've done post-trial interviews for hundreds of times. So I have a pretty good idea of how the process works. In a survey, I can ask those case-specific media items. Well, someone says, I just recall what was in the newspaper to the open. I can ask a follow-up. Have you read or heard if David Nichols was convicted by a jury for murder? Could never do that in a voir dire because you'd be poisoning the well, just like in the John Fight case we mentioned. I rarely see during voir dire somebody admits of comments on something like, oh, I read this. And then there's a whole discussion and explaining to everybody, well, that's not really true. That fact was just in social media. It's wrong. That is not a normal common thing that I've seen in voir dire.
In your experience, 15 years, you said, doing this work, have you had a situation where you've been stopped midway through your process?
No.
What do you care about?
What's what?
What do you care about? I've heard you say that whether what the media sends out there, whether all of those things are actually true or whether it's a spin off other information, that's not what's important to you. What do you care about in your work?
What I'm interested in is assessing if there's prejudicial media coverage. Inadmissible prejudicial media coverage is some of the most concerning. Misinformation is some of the most concerning. What I care about is what extent of that stuff has permeated the jury pool. What do people know? And do those specific details generate bias, prejudgment? Again, I just, the idea that there can be all this stuff out in the public
It can be
that's
biased by truthful information.
prejudicial,
You
that
shouldn't know
benefits
it.
one side. And you're not allowed to ask if people know that detail because you might taint one person who already knows a whole bunch of information. But that, again, like knowing the detail about the stalking comment. Okay, that person knows all this stuff. But that's the thing that's going to change everything. And now that person's poisoned because they heard it in a survey. But the fact that there's thousands of newspaper articles and television stories and comments on social media, 80% of people in this community have talked about this case according to the survey. None of that matters. It's because I did a survey and asked that question. I mean, that's just, I don't
Thank
even know
you.
what to say.
The burden shifting is quite annoying on that one.
Still want to finish the surveys if we're allowed to do them right?
I'm sorry?
Will you still do the surveys if we're allowed to do them right?
Yes, if we're doing them correctly, I'm open to continuing. Now, I think this whole thing has created quite a whole new narrative that it's almost wrong that the defense is doing something inappropriate by doing the same standard survey that's been done hundreds of times in other cases, including in Idaho. So I don't know how people will respond because of all of this and what it's generated, but I would certainly try if we're doing the survey correctly.
Thank you. I don't have any questions.
Okay. So one thing I just want to sort of clear up, because it's come up here back and forth, with the questions that aren't true. Okay, and those were not in the probable cause affidavit. And so I think it does have some bearing on the non-dissemination order, because our whole purpose, okay, both counsel were trying to protect these things from coming out to the public or to the media. That's, I think, one of the key
Shut up.
issue, okay, or the concern about these particular statements. So there were two questions right at the end. And the ethics, okay, of the lawyers, basically this non-dissemination order is really a mirror of the ethics in Idaho, especially for the lawyers who are participating in a case like this. And one of the things that is permissive for help in putting this information out to the public is information contained in the public record. Okay, so the public record is a case file that is available to the public. That's the law.
Then you should have said in the case record.
To then
In the public
say,
available
well,
case
we
record.
have these other issues, okay, of concern that have been spread through the media, hundreds and hundreds and hundreds, as you've said, that we need to test that. But then it is a tightrope to balance this. So I'm just not accusing anybody. I'm just saying this is one of the things that's pushed or pulled both sides apart and puts me in a very difficult situation, okay, trying to make that fair for everybody. Okay, so that's what that's about. I'm not asking you to answer anything.
No, I'm just trying to think about a solution.
I don't know if there is a solution, okay, it's out there. But it does have some bearing on additional surveys. And what you're saying is, if you can't use this, or apply the surveys that you want to complete, that you need the same questions. Otherwise, it's not legitimate.
Yeah. Well, let me ask you this.
Okay, so if you have an answer to that,
Let me ask you this one. So if you said you can ask certain case, like media items, like the other 7, for example, that may come from the record. That's a possibility because you can still measure what we're talking about. The specific knowledge when you ask these questions is high. The more you know, the more likely they are to be prejudiced and biased. And you see differences in the ADA count or a different count. Now you have to acknowledge there's these other stuff out there that's highly prejudicial. And we will not know if the rate of the awareness of those details are as significant as they are here. So then it's an unknown. So if the argument is, well, it doesn't look so bad because all I know are the things in the affidavit, for example. Well, there's this unknown out there again, because those items happen to be one of some of the more prejudicial items that we found.
Yeah, this is a death penalty case, and so when we're talking to jurors, we're going to probably talk to a lot of jurors individually,
Sure.
and it's going to be on the record. And we're going to talk about them, about what they think or what they've heard in real detail. So there's that. Okay, so I guess I'm kind of wondering too, in terms of all the people that may have been called that didn't pick up the phone or don't want to pick up the phone because everybody knows, okay, that, oh, I don't know this person as my phone is ringing.
Yeah.
And I'm not, and then there are lots of people, including me, that would never answer a question, okay, on the phone. So how do you deal with that? How do you balance that? There could be, 400 people
There's
out
always
there in
selection
Latah
bias
County
in a
that
survey.
say, I don't want to say
Some
anything
people
about
will
this.
answer,
Yeah.
How do you factor that?
some people
Well,
won't.
so you have two things. So let's unpacking both those. So the jury selection question, like I'm sure you've done a million of these. I've done quite a bit. I've done a lot of high profile ones. And from my experience, asking people in the general case, like a DUI, what do you think about DUI? And they tell you generally I'm against it. That doesn't, or I have a big issue with that, or whatever. That doesn't mean they can't be jurors, because it's a general attitude. It's nothing case specific. And there's hundreds of studies that show general attitudes are much less predictive than specific attitudes. This is different and unique because we're talking about attitudes and beliefs specific towards this case. That's a whole different animal. And that's the unique nature of high profile cases. So when you talk to people individually, you still have the memory issue. You still have the recall issue. Like you will not elicit everything that jurors. It's just memory does not work. It doesn't matter if they're under oath, private. There's so much research on it. It doesn't, our brains don't change just because we're under oath. They work the way they work. Your other question goes to response bias. Like what's the response rate? Is there something unique about people you miss and so on? So there's a lot of work on that. And one of the things we do is why we collect like demographic information is to see, are we missing groups? Are we overrepresenting one group or the other? If we are, is there a relationship between that factor and bias? And there's a lot of research on response rates, and what it finds is surveys that have high response rates where like everybody takes their survey, and surveys that have low response rates where it's like less than 10%, and you compare them with public opinion polling and so on, politics, there's no difference. You find in most instances, the results are the same in surveys. So high response rates are not necessarily correlated with more reliable, valid survey findings. And that's something they've done a lot of work on because survey rates or response rates have gone down quite a bit. I think yeah, they have. For sure.
Well, I mean, so could be that you're just getting people who like to talk on the phone.
You're
Strangers.
getting that.
Yeah,
Judge.
and from this case, I think people are so invested in it, like a lot of unique
He's
things.
telling
So
you
people,
there's
talking
ways
about
to
what's
know if
happening,
that's
they're very invested in
statistically
this case. It's unique.
significant.
It's a small community, it's not surprising. But just what I'm finding, and there's so much prejudgment, detail, and so on. I don't think I think it's fairly representative of what you're going to see. Almost everybody in this jury pool knew about the case, like comparable to like the George Floyd case. The bias was the same in terms of comparing it, not to Chauvin, who was the one George Floyd, but Alexander King, who was another officer on the scene. Like the rates are similar to that. So that was another high-profile case that was a lot of tension and stress, and so on. And we still got very meaningful data. And we've done this so many times. Like you kind of understand, like response rates are going to be lower, but there's nothing to indicate that, for example, we're missing an important group. And if we were, we would weigh the data to account for it. So there's just
So in Latah County, it was about 1% of the population.
Yeah.
So hypothetically, if we say, oh, I mean, one of the counties that you're interested in is Ada County. which is obvious.
Yeah.
For other reasons too. But would it be 1% of the population in Boise? No.
So
Okay, so that's, I was kind of wondering about that. You have to talk about, 2,000 people or something. Okay,
Can I explain how that works?
yeah, go ahead.
Yeah, so it's a great question. So you can take a small sample and generalize to the population if it's done correct. So like if you look at surveys of the United States, the sample sizes are similar to what we did here. Maybe it's 1,000. And now you're generalizing to every city, county, and so on across the country. Everybody has a known probability of being selected. How you pick your sample size, it's called power analysis. So remember, you know how you see polls of like, you'll see a number like 90%, and they say plus or minus 5%. So it's either 85 to 95%. Basically, it's plus or minus 5%. That's kind of the industry standard. And you take a conservative approach. So let's say you ask a yes or no question, you would say 50% would say yes, and 50% would say no. So that's a lot of variance. So that's the worst case scenario. How many people do you need to talk to? So if that happens, your confidence interval is plus or minus 5%. And that comes out to 400. So if you did Ada County, it would be 400, and your confidence interval would be the same as it is here with a small anyway. So as long as it is using the general concept of a randomized sample, you can generalize that population with this.
So if I kind of interpreted this, with one of your answers just a moment ago about the getting rid of the questions that are false, okay, that just came from the media, that did not come from the public, well, from the public, but not legal part. Could you go ahead with that and have legitimate data?
So I think you have the
Told
9
you.
questions. So if you look at it, are the other ones okay? Are you telling me there's 2 that you would like to exclude and keep the other 7?
Well, maybe. I'm not, I haven't made a decision, but I'm just wondering if, I mean, at first, in your
Talk about it,
testimony, you
expert.
said, well, if we can't, I can't do it without doing the same questions. That's one of the problems, okay, that part of this argument. I mean, if maybe it can be done without sort of sending information out there that is false, that might, affect people or looking
I feel
into
like the
that and
judge
thinking
hasn't heard
that
anything
is,
from the last
they
90
believe in it.
minutes.
even though they shouldn't. Is that something
Already
that can
explained.
be done?
Well, if you do it that way, there are potential confounds and things that
You're
will arise.
biasing the survey.
And again, the thing I struggle with, and I understand the public record dissemination, so we've done this before. The thing I get to is like, we're not really disseminating it, we're asking if people know about detail that has been disseminated through the megaphone of the media. So I'm really trying to just track what people know. I'm not trying to pass on information through a megaphone. So we're talking about 400 people that are talking to out of the county of 500,000 or something, Ada County. The plus the risks and benefits of doing it that way. Seems like there's a very low risk of undermining or contaminating the jury pool when you're doing that, versus the risk of getting a huge black hole of, well, we don't know what percentage know this highly prejudicial detail. Like, what are the odds, or like what impact is doing the survey going to have on the jury and the community relative to the media coverage that's already out there? So
Do you ever put a caveat on the beginning of the questions where you say, well, we want you to understand as we go through these questions that we're not determining guilt or innocence. We're not determining false or true. We just are interested in our your answer to our questions, and we want to be careful that we're not sending out something that you are not going to understand.
So Yeah, so we do always, there's an introduction and there's kind of like, there's no right or wrong answers to any of your questions. You could always say no opinion or I don't know to any question. It's going to remain anonymous. We're just interested in your views. And so there's an introduction to that section with those 9 items. Usually it says you may have, we're going to go through some items in the media. You may have already reported some of these already, but we're interested in what you've seen or heard. We can add a caveat to that, like some of these may not be true, if that addresses it. Some of these things were, not all of these media items are actually accurate.
Sure. People pick up the phone for somebody and they think, you know, somebody with authority maybe, and they think, oh, well, this is really kind of the beginning of the trial or something. I mean, people misunderstand all kinds of things out there, right? So
You can certainly tweak the intro. Now, we don't just jump into it. We don't say we're an authority, you know, it's usually,
no, I know you don't say that. I just saying, you know.
yeah. So we can work on the introduction if that would address some of those concerns so that people understand. Not everything in the media is accurate, but the thing is, like,
We have
I
to
would-
spoon
if we're
feed
gonna
the
say, for
people now
example, not
that the
everything in the
doesn't
media
always
is
tell you the
true.
truth.
They get a lot of things wrong. You would not want to say that before you do the prejudgment question. You can do that after, when you do the case specific items, because what I want to know is what are people's opinions about guilt or innocence. I don't want to give them instructions and then get socially desirable response in a survey.
But you don't sort of measure it, this person as their bias until you get into the specific questions.
That's
Specific
validating,
stuff,
Judge.
because otherwise it's just yes or no, and you can't determine bias just from that.
Well, no, yeah. So the prejudgment question comes before the case specific media item questions, because then you would create bias. If I read those 9 items and then I said, okay, do you think he's guilty? I just told you all the stuff you might not know.
Yeah.
So the question is, do you know about the case? And then it's based off of what you've read, seen, or heard about this case. Do you think so-and-so is guilty of murder, whatever the crime is charged? And it's on a scale. Yes, definitely guilty. Yes, probably guilty. I know, probably not guilty, to know. Based off of what they've already been exposed to without you giving them anything. So they have no information beyond what they've seen in their home. And then you ask open-ended questions like, what do you know about the case? And then other things. And then you get to those case-specific media items.
And that's when you can theoretically measure bias.
Yeah, well, I mean, I correlate those recognition
Theoretically
items with the
measure?
prejudgment questions of earlier, right? So,
Correlation doesn't necessarily mean causation.
yeah. Well, they're chi-squares, you can do different things, you can do linear regression, whatever you want. But
Oh, boy.
what I want to know is, do people who report later on, they know that detail, did they report stronger views of guilt? So like, I'll give you an example, like if you only knew 2 of those items, prejudgment was only 21%. So if you only knew 2 out of the 9 items, most people had no opinion. Versus if you knew 7 or more of those items, it jumps up to 82%. So that's telling you, like, the more facts you know, more case knowledge you have, the stronger your opinion is, right? And that's what you see in the literature. That's what you expect to see.
So if somebody was being told, oh, that was just all false information, would that bring down the bias?
In what
Measure? But you were saying earlier that it's kind of pessimistic, I think, maybe, but maybe absolutely correct, that once people have an opinion, they're not going to let go of it, even if they get the truth.
Yes, yes. It's called belief persistence. There's a bunch of research on that.
That's kind of going around the
Yeah.
political
And we see it.
space right now.
Yeah, like if you talk about, everybody has an opinion of Donald Trump, so. if
I'm
you-
not going to say.
Yeah, I know, but if you,
Neither are you.
yeah, so.
All right, so thank you for that. Any questions online, Ms. Taylor?
Your Honor, I don't have any other questions for Dr. Edelman, and we do have a summary for the court at the appropriate time.
Okay. Mr. Thompson, anything online? Okay,
Sir, thank you.
so go ahead, Ms. Taylor.
Ms. Matlock is going
Oh,
to
you
give her
know what?
summation.
Okay, just 1 second. I'm ignoring the court reporter, and I'm just so immense in this that I need to worry about maybe rest. Are you okay?
Yes.
Okay. Okay, well,
Guys, it's 6:05 PM here in Idaho.
thank you, Dr. Edelman. Appreciate your testimony there. So.
So it is a late
are
evening
you
in court.
okay? Okay, great. Okay, let's go ahead.
Thank you, Judge. I realize it's late in the day, and I will tell you that this takes about 9 minutes for me to sum this up. But I do want to talk about something in advance because you're asking questions of our expert about his process and changing the process that is impacted in the United States Supreme Court law. And the United States Supreme Court law requires that part of the analysis for the court on presumed prejudice include false media coverage. It's not enough for it to be all truthful media coverage. So before you start suggesting that an expert change his methodology that's accepted practice, it's really important that you go back and look at Skilling and Haddon and the lineage of cases that get us to venue and what the court has to decide in determining presumption. The question you asked, be answered today, is where do we go from here in the survey process? I want to answer that question in two parts by summarizing what we can do and what we can't do. We can and we need to finish the process that the defense undertook. It was completely valid. It was standard in cases like this. Dr. Edelman is an expert in this field, and he has done this jury research and this work for 15 years. Nothing about the format, the methodology, the questions, or the fact of the survey itself was wrong. You've talked about two questions that you are describing as false because they're not in the affidavit. But if you look at that affidavit and what the media has done with those things is they have created a narrative based on the facts that are represented in the affidavit. Now, I would agree that there's a lot of information in that affidavit that is just flat not true. But if we focus on where we are right now,
Yeah, tell it.
there are representations in the affidavit about multiple trips to Moscow from Pullman and a return trip to Moscow from Pullman in the morning that lead a reader to the word of stalking, that you have a problem with that word being included. Reflect back on the case law in the United States Supreme Court about showing false information, but also look at that affidavit and the way the media has construed that in its representations, in its reporting that is so prejudicial. Because the basis for this spin, the foundation is right there in what you are describing as the public record. Now, I fundamentally disagree that the only public record in this case is
Thank you.
what's there on the 12-page docket. The public record in this case that the entire nation, the world, and looking at, and especially Latah County, is derived and construed out of that public record.
So can I ask you a question about that? This public record thing is really kind of circling around because what's the purpose then of the non-dissemination
Yeah, Judge,
order?
it's so that they can't
If
attribute false
everything out
info
there in the
to
public
official sources.
is the public record.
They can
Well,
make
my
shit up, but
understanding,
they
Your
can't
Honor,
attribute
is
it
that
to the prosecutor.
It's the one of the primary issues was the credibility of the person that is out there speaking. We did not want law enforcement, 159 officers out there talking about police reports and disseminating that. We didn't want the prosecutor doing press conferences like we saw on 12/30/2022. We didn't want the defense getting up and doing press conferences based on the information, because we have information that no one else has, and we are consulting with experts that the public doesn't know about. And so we have a level of credibility that the others don't have. And so that is my understanding of what we're trying to get a hold of. And it's been pretty effective in this case until this valid survey that happens in high profile cases has been construed to be something nefarious, which it absolutely is not. As you've heard, it's been used in Boston bombing, the Parkland shooting, the Colorado theater, George Floyd, hundreds of cases going back decades. Dr. Edelman's declaration and now his testimony are uncontroverted evidence before this court on this issue. It's the actual evidence that the court, and finally today, you're getting informed about the validity and the science behind the process. Nothing that was done is worth the hysteria and the hyperbole that keeps getting expressed in this courtroom. The questions asked, the topics, the order, the open-ended, the specifics, they were all done using information that is out there for everyone to see. And the research methods used to determine what was out there is the traditional way and the scientific method that experts in this field use, just as Dr. Edelman testified. And to be sure, the purpose of this is to give you information so that you can make an informed decision about venue. It's not for a nefarious purpose. It's to arm you with facts and information so that you can apply the United States Supreme cases that have been adopted in Idaho and determine whether or not there's presumed prejudice. You know, when we first started talking about whether or not there was going to be this venue hearing sooner rather than later, Ms. Beatty for the state said at least 3 times, Judge, they can't just come in here with affidavits. This case law says that they have to have more. The more that we are gathering to provide you, at least part of it, is this survey. In terms of the proposition that this survey taints the jury pool, first of all, you heard from Dr. Edelman that if someone answers they don't know, a second question tapping into that is asked, and the process stops. There's no other questions other than demographics because they don't want to poison anybody who doesn't know. So for there to be this proposition that all of these questions, these 9 questions that are later on in the process were put out there intentionally to poison the jury pool, that's just flat false. And the other point is you can't taint what's tainted. When you hear what the statistics are, as it relates to this county, 97% of the people had familiarity with the case. 79% of the people knew 5 or more prejudicial and false media reports. 81% of those who had heard about the stalking had determined and took a position that Mr. Kohberger is guilty. These people that were surveyed didn't form the opinion when they were being surveyed. And they didn't then go research their already strongly held opinion because of the survey. These are deeply held opinions in this community within this jury pool. The Latah County citizens have accepted the information placed before them by state actors. It's not just Mr. Thompson that did a media report and talked about the probable cause affidavit. Chief Fry, the coroner Kathy Mabbitt. We've got search warrants from Pennsylvania out there in the public record. We've got hundreds of search warrants in the public record out there from Idaho. We've got all kinds of pleadings. This is all information that's put out into the media. And having the state now claim this moral high ground is an oxymoron.
Preach.
It's a complete oxymoron for state actors to put this information out in the public and now say, hey, wait, if you want to ask if people have believed the information that we put out there, you can't do that. That harms Mr. Kohberger. We as a defense team have the obligation and frankly, the privilege of defending Mr. Kohberger and defending his right to a fair trial. And in doing so, if arguing that venue should be changed, we have to show you that there is presumed prejudice in this community. And since we have the burden of this, and you now know essentially from this expert that there is presumed prejudice in Latah County, you have to ask yourself, do you want more information to know where the better venue is? And that takes me to the next point, which is what we cannot do. You've heard Dr. Edelman say that it goes outside of his standard of practice and the scientific method that has been used for decades, that has been used in hundreds of cases to take your ideas about what should be in questions, to take the state's ideas about what's being in questions, should be in questions in the survey. He follows a process. That's the process that he needs to follow because he has to provide the court with apples to apples comparison. Another issue that was addressed last week that I want to touch upon, and there are two, is this concept that if we just done a juror questionnaire, it would have addressed all of that. At the stage that we're at now, which is setting ourselves up for and preparing for a venue hearing, we have to justify a venue change. The standard that you're going to be looking at, according to the Supreme Court, is whether or not a presumption exists where the record demonstrates that the community is saturated with prejudicial, false, and inflammatory media publicity about the crime. The case law mentions false media publicity about the crime. That's what the survey assesses now. Another way to determine actual prejudice is a questionnaire, and that is done prior to selecting the jury. And at that time, we are looking for actual individual bias of the prospective juror. There are different methods used at different stages of the case. And right now, the proper method is a survey. Another solution that you mentioned last Thursday was simply to strike 400 people surveyed from the veneer. And I want to talk about that. First of all, that doesn't address the problem that's very clear that we have in Latah County. And so if you extrapolate the percentage of people that have drawn a conclusion about Mr. Kohberger's guilt, if you extrapolate that to the county with numbers like 81% have concluded if they are familiar with the media information about stalking, there's no prospective jurors in this county. You mentioned, this is 1%, but there's much more analysis to what the prospective jury pool is here. First of all, the jury commissioner, I think you talked about her when we were talking about whether or not jury trial was going to be speedy trial was going to be waived. You said, I think it had expanded the pool to 1,000. Am I right about that number?
I can't remember. It was maybe more.
Okay. So if you extrapolate the numbers that we know of prejudice exists, I mean, that leaves us with a very small jury pool for trying to do voir dire in a death penalty case. But if you look at the population of a whole, what the U.S. Census says about Latah County is that almost 18% of the population here is under the age of 18. Almost 18% of the population here is over the age of 65. That eliminates, close to 35% of the population that's even eligible to be in your jury pool. Second, and more importantly, I can't find statutory and legal authority for you to strike 400 people out of the veneer up front. I found the opposite. As you know, the clerk or the jury commissioner pulls from the jury pool that's approved by Idaho Code. And this is a really important section in Idaho Code 2-202. It is the policy of this state that all persons selected for jury service be selected at random from a fair cross-section of the population, and that all qualified citizens have the opportunity to be considered for jury service.
Rest assured, I was just being sarcastic.
Okay, well, I
Oh,
took your
were
sarcasm
you?
to heart, I guess, last
I
week,
apologize.
because it was a very serious day, right?
Every day is very serious.
Right, but last Thursday was in particularly a tough one. I think we can all agree.
There's gonna be more tough ones ahead, I'm sure.
For sure.
So
for
we're having a
sure. And we
serious
all
day
need
where
to
we're
give
being
each other
sarcastic on the
grace.
bench.
Thank you.
Thank you, Judge.
I will end by saying this. Our defense team firmly, and I mean firmly, believes in Mr. Kohberger's innocence. And right now, he's being held to have a trial in a county that believes that he is guilty. In this country, we pride ourselves on a jury system that doesn't stand for that. In this moment, I see that you have two choices. You can let us continue and do comparative surveys as planned, or you can maintain the stay. And at the venue motion, you will hear that the data for Latah County shows a presumption of prejudice, but you will not have comparative surveys to fully inform the court. As you consider this, there is absolutely nothing that gets risked if you change venue. But if you deny a change of venue, Mr. Kohberger's constitutional right to a fair trial is denied.
Right
There's
now, in
only
fairness,
one
he is kind
human
of
being in
pre-litigating
this
a little bit
case
here,
with
but
a right
hey,
to a fair trial. It's Mr.
Bill knew how to
Kohberger's
object
and
correctly.
his alone. There's no legal right of this community to have a jury trial here. Thank you.
Thank you. Mr. Thompson?
Thank you, Judge.
We can get a mood change here. Little tone down on the histrionics.
Let me bring this back into perspective. Our motion deals with the court's non-dissemination order. It was agreed to by the defense. In fact, the idea of the non-dissemination order was initiated by the defense with their February 30th, 2022 motion for a non-dissemination order to prevent extrajudicial statements. That would be statements outside of the public record, which is the court record, that have a substantial likelihood of heightening public condemnation of the accused. And the state's position is that the fact-specific questions, and I understand from Dr. Edelman why the questions were asked. I understand his explanation. It doesn't change the fact that we have a non-dissemination order that specifically prohibits that kind of dissemination of facts, specific facts about this case. Facts that include those that are not true, acknowledged from the stand that they are not true. Which, interestingly enough, I look at the PowerPoint and slide 15, which talks about the American Society of Trial Consultants Professional Code on Venue Survey, says false facts should generally not be used to test accuracy of other responses in venue
I
surveys.
knew he was gonna
So if
look
false
at them
facts are used,
chatting
they
there.
must be
He was gonna
clearly false.
misrepresent
No
that.
possibility that the respondents know about the case, use false facts, true facts that have been publicized. We have an inconsistency there, which frankly is
He
logical.
didn't cross-examine
It
on
makes
that, did
sense.
he? Did you, Bill? You
And
didn't
the state is
actually
coming
want the
from a
expert to
point, a
explain what
position
that
of
meant.
being practical and trying to use common sense here. As I listen to what we have heard today, and in part from last week, it seems that the position of the defense is it is okay to risk tainting additional jurors in order to ascertain bias of other potential jurors. And I'm not sure that that's the way this court should do business. If we accept what the defense is suggesting at this point, and again, we are not arguing venue today, and so I'm not going to try to get into all these numbers and all those sorts of things. We'll save those for another day. But if we were to accept that we have perhaps on one issue 20% of the jury pool statistically available, well, that's more than enough people to select a jury from. So it's not nearly as overwhelmingly compelling as I think is being suggested here. I want to be clear again. Ms. Massoff used the word nefarious several times, suggesting the defense was, or that the state was accusing the defense of being nefarious. And sure not, Your
Yeah.
Honor.
You did.
I am not suggesting that there was any ill will or motive by anybody over here.
You said they
What
poisoned
we
the
are
jury.
suggesting and what we believe that the record shows is that this court issued a specific order prohibiting the dissemination of specific types of information, including the identity or nature of evidence expected to be presented, including the performance of results of the examination or test. There's no question that those 9 questions included violations of the court's no contact order. That's what we're here about. And apparently there was some miscommunication or misunderstanding about the integrity or the importance of the non-dissemination order. It sounds like today that maybe because these types of surveys are common nationwide, then the non-dissemination order really doesn't matter, which
Because
is
we
a little
all
disconcerting.
understand the First
But
Amendment.
I don't care about what happens anywhere else.
That
All I
applies
care
in other
about is what
places
happens in
too.
Latah County. In this court, it's far above my pay grade to go and analyze what happens in a big city or some other part of the country. I know Latah County. That's where my interests are. That's where our interests are here.
You're not exempt from the First Amendment in Latah County, Bill. You don't get to gag the lawyers.
On the issue of whether the survey can be changed, I think that does present some challenges based on what we've heard here today. But the solution for that is very easy. We just back up, and if the defense wants to pursue the survey, they do a new survey with a new group of people and take out the objectionable questions.
Oh, so now we
And
want
then
to
once
take more
they've done
people?
that, they can proceed to do that identical survey in other veneers around the state, whichever ones they want to select. And that would be the proper way to do this. Now, we may hear, oh my goodness, that's going to consume time or that's going to consume a lot of money. Well, I'll tell you right now, I don't care. If it can't be done right, or if that's what it takes to do it right, then we need to do it.
You're the only one saying
This is
that's
a
the
big
right way to
case.
do it.
And the finger for this cannot be pointed at anybody but the defense. I'm not suggesting an evil intent, but the practical effect of the decisions made on behalf of the defense was to ask these questions and to create a situation that we've been having to deal with now for 2 hearings over the past week, well into the evening on a Wednesday. That's the way forward, Judge. Thanks.
Well, quite some backpedaling there.
Go ahead.
Judge, I'm just gonna end really quickly with this. We didn't violate the non-dissemination order. You know, the information that now he's calling facts, you know, he's flip-flopping between whether or not it's a false fact or a fact that's in the survey. The information that was put in the survey is based on the public record and information that the way that the state and state actors put information into the public record that has now been disseminated. And we have not violated that order. And I do resent being accused of that.
I appreciate that. I mean, those 2 questions were not in the public record. Okay. They weren't. I mean, they came out, but that was not the court. I mean, where it came from. It just came out of the media or somewhere. Who knows where it came from? But I don't think there's anything, not that I'm aware of, in the public record that said anything about that, about your client. So, I mean, here we are. I mean, that happened. It's kind of unfortunate. I totally understand the the reason to have false information out there, but I mean, I have to just want to clear that up. The other questions, that's all from the public record. I have a question. But anybody tell, if you can find somewhere in the public, public record that those, claims were made, I'd like to see it. But I think both sides are looking at a different definition of what public record is.
Yeah, that's what happens when you make your orders ambiguous,
I,
which you can't do
Hey,
when you're
look it up.
gagging people.
It's the public record from the case. So that aside, I appreciate the testimony, the arguments from both sides. I think it's a challenging issue. It's something that I'm going to have to struggle through and figure out what to do. And I understand that there's some urgency to get that out, so I'll do my best. Probably not gonna be this week. So. Anything else we need to talk about? Ms. Taylor?
Your Honor, just the logistics of the court's decision is yet to come. We can't continue the surveys. And we've got deadlines next week, midweek for briefing and the motion for change of venue for May. So I'm wondering if we want to consider resetting that motion and that deadline now. I still want to keep the hearing on May 14th. We have a motion to compel already filed to be heard that day. So we could still use reserved court time to make some further advances in the case. But I'm concerned about being properly prepared for the change of venue, waiting for the decision, especially if we're allowed to continue the work.
Sure. And I told you last week that I would give you more time. I won't be fair about it. So you want to change that hearing? You want to leave the May? We're set on May 14 at 1:30.
We have,
You want to keep that for the motion to compel,
yes, please.
but you want to move out the hearing on change of venue.
I believe that's the only prudent thing to do at this time.
Yeah. I mean, you have to.
Yes, Judge, I think that we should, based on some availability of team members and experts, though, I think we're not ready, or we won't have the team available until the 4th week of June for all of the people that are necessary.
You want to just wait and just talk to each other, just, have a hearing again.
Judge, I don't
I
think we're gonna have an agreement on the change of venue issue. If I thought we could come to an agreement on that, I'd say, yes, let's not set one, let's talk.
Oh, no, I'm not suggesting that you would agree on agreement on change of venue. I just mean changing the hearing, the date.
Your Honor, we would suggest the last week of June, and if the prosecutor's ready to weigh in on that and the court's ready, we'd prefer to get a date now.
Okay. Mr. Thompson, what are your thoughts?
Yeah, I think it would be appropriate to reset the dates, and really what's going to drive this in part, well, in large part, will be your Honor's decision on what we've been talking about today. But I think it may be prudent for the court it would be prudent for the court to vacate the hearing on a motion for change of venue and prepare to reset a briefing schedule and a hearing date on the motion for change of venue to a reasonable future time,
Okay,
to allow the parties to react to whatever the court's decision may be. And I don't want the court to feel pressured on the timing of its decision. I'd rather take the time to do it right than to rush
Oh,
things
yeah.
and just bollocks.
No, you don't want to rush.
Well, I won't rush it. And I will feel the pressure.
I mean, it isn't Friday
Appreciate that,
afternoon, so
How about we set this for 1:30? We'll vacate the hearing on change of venue and reset it for January 27. That's a Thursday, which seems to be a good day.
it said
for
January,
this
but I think we mean
generally, except
June.
today. What did I say? June. Sorry.
Your Honor,
It's a long day. June 27. I thought you said the end of June, right?
June 27 is perfect. I am thinking though that we should maybe schedule for a full day. We estimated an hour for this and we're well beyond that now, and we anticipate testimony.
There's 10 o'clock. Will that work?
It will, thank you.
So an all-day-ish hearing on June 27th.
That work for you, Mr. Thompson?
Yes, sir, we are available that day, at least those of who we were right here.
Okay, and that includes Ms. Jennings.
And hopefully Ms. Beatty and Mr.
Well, I'm gonna ask them next, and then I'm gonna go to Ms. Massa.
I'm good.
Okay, great. Okay, Mr. Nye and Ms. Beatty.
Yes, Your Honor, that date and time works for us as well.
Okay, perfect. Okay, 10 o'clock, June 27. Okay, is there anything? Oh, yeah, briefs. What do you think, Ms. Taylor? I mean, I know you can't
Yeah.
know until I
How is she
give you
supposed
a
to
decision,
answer?
so.
Your Honor, the briefing schedule that the court gave us was roughly about a month prior to the hearing. We could try that, but if the court's decision takes a while and if we're allowed to finish our surveys, then we might have to have some time to do a supplemental.
Sure. I'll be flexible about that. Let's say hypothetically that we have more surveys, then we might even have to push it out.
That's
I don't-
possible.
Yeah. Especially, no. Yeah. Mr. Edelman, Dr. Edelman told me that, you don't necessarily, if you go to a larger population, that you have to have a percentage of it. It's just,
400 people.
and with, I think, the magic of statistics.
Your Honor, if we're allowed to finish what we started, we think from the time we could get it going, it would be 3 weeks. And then Dr. Edelman would need a bit of time to assimilate the data into a report.
You think, if all went well, that, you could have your briefs or whatever other information by May 31st?
Yes, yes. Your Honor, with a caveat, unless there's a long delay.
Caveat, okay?
If there's not a long delay in me knowing what we can do, yes.
Thanks. What do you think for the state, maybe a deadline of June 14th? So,
I think that Ms. Beatty is going to be handling the venue issues. So how about we ask her?
Okay, Ms. Beatty?
And Your Honor, Mr. Nye and I will both be handling that, but that works for us.
Okay, fantastic. And then maybe a reply by June 20? You think?
We can do that.
Okay. That'll give me time to look at all that before the hearing on June 27th. All right. Thank you for your patience. Anything else? Then we have to talk about this one motion. You said we'll put it at the end of the case, and the end of the day.
Oh, the prosecutor's filing. Yes, I'll take
Yes.
a look at that with him before I
Okay.
leave the courtroom, Your Honor.
All right. Is
We-
there, go ahead.
If the issues that I have, if they're redacted, then we'd have a stipulation. I'll just show them what I was talking
Let's see
about.
if we can do that.
You two can.
Yes, sir.
all that. Okay. Anything else then? Ms. Taylor,
No, Your Honor, thank you.
Mr. Thompson.
No, sir. Thank you.
Okay, thank you for everybody's endurance and have a good evening. Thank you.
Well, well, well.
Sorry.
And that's it for the live stream. All right, guys. Well, who wants my prediction? Yeah, I think they're going to go with that little middle ground that he was able to kind of negotiate from Mr. Edelman, where you might be able to tweak the introduction just slightly to make it clear that what you're asking them about is not necessarily truthful information. Otherwise, I think he's going to let the survey go. That was absolutely freaking bomb today. Okay, that expert is fantastic. I love experts who can break stuff down. They can deliver you very high level information. Like, we weren't being spoken to like kindergartners, but at the same time, he's able to just simplify it in a way that you can understand when you're a layperson. You don't have a big background in statistics and surveying and things like that. So he was extremely effective. I'm so glad that we got to hear from him. Do kind of wish we had heard from him last week. It might have solved some of this issue with the media creating this whole new narrative of now the defense has done something completely and totally wrong. Well, if we had heard from him last week, that might not have been such a dominant narrative. But you know, it is what it is, and we get what we get. So I'm still troubled by the judge coming back to this non-dissemination order in the public record, because he's implying that the defense can't talk about the press. And I just do not see that withstanding a First Amendment challenge. That's a problem. The problems with this gag order, I said it last week, there have been problems with this gag order from day one. There are kind of always inherently problems in a gag order unless you limit it down to just that pure, bare ethical standard of what you're allowed to limit. And we see it in this particular case with the public record. He didn't define that term. That's not their problem. That's his problem. You chill people's speech unnecessarily when you use language that's ambiguous, so it's not clear what you're talking about. And then if that can be interpreted in a way that covers both protected and non-protected speech, then people are going to shut up about things they have a right to talk about because they're going to be afraid you're going to hold them in contempt for violating this order that you didn't make it clear what it applies to. So this is a very basic First Amendment principle with any type of restriction on speech. It can't be vague. It can't be overbroad. And so his interpretation of the public record and what they're allowed to talk about in the public record there is very restrictive. And that to me does not at all follow from the context of this case. He didn't say it's only the court record. He didn't say it's only the things that have been filed here that we're not sealing off for confidentiality purposes. And finally, you always have to interpret these things in a way that's going to be consistent with the First Amendment limitations. Talking about the press is very, very unlikely to create, remember the standard, substantial likelihood of material prejudice to the right to a fair trial. The press is already out there. The defense comment is a drop in the bucket. Like this expert pointed out, to people who were pretty much, by and large, already tainted by media exposure in this case. We're a year out from trial. This is not our actual jury veneer. one of the things that I appreciated them drawing out a little bit of the distinction between the way you do a survey in this type of context right now versus what you do when you're actually talking to a jury panel, when you're actually in voir dire, because right now we're not talking to our actual jurors. We're talking to people that have, at best, some slight probability of being summoned as jurors. Once you get into voir dire, yeah, those are the people you have to choose from. So if those people get tainted with information, it's quite a bit more significant. It has a more direct impact on your ability to get an impartial jury than to talking to people that, you know, may not ultimately end up being summoned in the case. And again, because when you're doing voir dire, you know, your trial is going to start like now. You know, you're technically already in the trial. They're going to be hearing evidence within a matter of days. They're going to be making a decision shortly. It's not at all like a survey that's being done a year ahead of time, you know, based on information that is, by the time we get to trial, you know, there's going to be so much more that has been reported on. These details, you know, are going to go through just different processes of circulation and recirculation and reformulation. And the reality is kind of that the media narratives are what they are. They're already set. And so whatever new information comes out in the case is going to be spun in whatever way suits that narrative. We already know that. We've been watching it happen for, you know, a year plus already. So, yeah, I kind of enjoyed the deflating of Bill Thompson in this hearing. Nothing really irritates me quite like the prosecutor that's on their moral high horse. It really does. You know, this is just, you know, obviously I'm a defense attorney. I have my biases in that respect. I have my perspectives on, you know, who wears the white hat and who wears the black hat when it comes to criminal prosecutions. But it's just such a common theme for the prosecution to walk into a criminal court all just pumped up with that sense of their own moral, self-righteous importance, and, you know, proudly pound the table and demonstrate their outrage at this great injustice that they have to go to court to talk about. And so to see that balloon get popped, watch that deflate a little bit. I personally do like that. I find it typically to be, honestly, a kind of arrogant position that prosecutors take. And I understand, you know, first off, again, not all prosecutors. There's, of course, individuals, and some of them are good and stuff like that. But it's just kind of the nature of the job that if you are going to be out accusing people of being bad people, of being criminals, you're a terrible person, you deserve the condemnation of society, that you have to, you psychologically kind of have to marshal quite a lot of certainty about how right you are in making that accusation. Because when you accuse people wrongly, you know, that's pretty bad. And most people would feel pretty shameful and guilty if it turned out they were doing something like that. So there's a lot of self-protection in this attitude that, you know, it just, my perspective kind of encourages prosecutors to showboat a little bit with their righteousness. And as we've seen, they can be mistaken. And so to see him get a little bit humbled by this expert explaining, no, the jury is not being force-fed anything. No, nobody is being tainted with stuff. No, if you didn't know anything about the case, you weren't being asked these case-specific questions. No, you were already volunteering details of what you knew about this case that were correlated with a higher incidence of prejudice, of bias against Mr. Kohberger, regardless of which specific details are the ones that you had been previously exposed to. These were the critical factors that we needed to know about this survey to understand, why does it have to be done this way? And you know, Bill Thompson got a lot of time, a lot of opportunity last week to be able to try to set that narrative of this is bad. And why? Well, just apparently because he thinks so, because he doesn't like the questions. And so just really, I'm very pleased, very pleased that we got this record from the expert explaining exactly why it needs to be done this way. You can't measure what you don't ask about. And it just goes back to, again, what we talked about last week. It's the elephant in the room. You can't just pretend it's not there and then assume you're getting an unbiased jury. That would be malpractice on the part of these defense attorneys to just ignore the elephant in the room and not ask about it. So, I mean, regardless of what happens with this particular motion and this non-dissemination order and all of that stuff, I mean, we still have the same problem that this doesn't apply to the media. It's only the state that has the gag. And the way that they turned that down, to turn that around on Bill Thompson, boy, that was masterful. That was an excellent move today. I about died when I saw that media clip of the press conference on the PowerPoint presentation. Because yes, the defense didn't cause this problem. And not only did the defense not cause the problem of the bias, they're the ones that have probably benefited the least from having this non-dissemination order in place, because they haven't been able to correct the record other than just these limited pieces of information that they're able to bring out in the court hearings and in their pleadings. Now we know, for example, the stalking is false. Now we know the following them on social media, it's false. Y'all made that up and you know it. And guess what? We all know which outlets are going to continue to report that as if it is factually true, because, you know, they're shameless liars. So it's the defense that has been unable to counter the bias that is out there because of the state and its agents and the media relying on the anonymous sources, et cetera, et cetera, et cetera, that just couldn't get enough of this case, couldn't provide enough details and information and interviews and stuff about what was going on before they even necessarily knew what was going on. And you know, if you were following this case in the early days, you saw the kinds of problems that caused as well, because there's backpedaling, there's information being put out, then it seems to be retracted. Well, first we're hearing that the house is a target of, you know, it was a targeted killing, so nobody else needs to be concerned. But then later, you know, well, we don't actually know any of that. And just this rush to, I guess, put the community's mind at ease, which I can certainly understand. You don't want the public in a panic, but if you don't know if there is a safety problem still, you're not doing anybody any favors by just kind of putting stuff out there to calm them down when it turns out not to be true. So all of this sensationalized media has created this problem. The defense has never had an opportunity to combat that, to put out their own version of, actually, you know, this stuff is false. Actually, this other stuff that we're exploring is true. Actually, you know, there's this other things that you haven't even heard about that are going to bear on the evaluation of innocence or guilt in this case. And yeah, I guess they can't even ask about it. I mean, no, that's just not the standard. That is not how it works. I had mentioned during the stream when it came up that this guy worked on the Boston bomber case, and that was it was one of those sort of synchronicity types of things for me, because when I was just thinking about some stuff about this issue, I came across a brief that the American Bar Association had filed in the Supreme Court case for the Boston Marathon bomber. And so what had happened in that case is that this was Dzhokhar Tsarnaev, and so he was convicted at trial. And during jury selection, they had tried to ask these types of what they call content-based questions, to ask the jury specific questions about what media you had been exposed to. And the court in that case didn't allow those questions to be asked. They limited the voir dire to just those general types of questions of, have you seen, anything? Have you seen media coverage about the case? And can you still be fair in spite of having seen that? And so, of course, lo and behold, everybody, says that they can be perfectly fair and impartial. Well, when it goes up to the Court of Appeals initially, I forget which circuit it was from, but anyway, the Circuit Court of Appeals had originally held that was error, that the judge needed to ask those specific voir dire questions because that's the only way. I mean, all the things that we just talked about, this expert just talked about today, that's the only way you can know what the exposure is and what the effect is. If you don't have a factual basis to evaluate whether somebody is biased or not, then you can't make a meaningful decision about whether they're biased or not. You're just basically taking their word for it. So it went up to the U.S. Supreme Court. The American Bar Association wrote a brief, an amicus curiae brief, on this issue. They didn't side with either party. But they took the opportunity to write this brief to emphasize how, under their own standards for criminal justice and how trials are supposed to be conducted to get an unbiased jury, they have for years required, set as a standard that these specific content-based types of questions be allowed. And again, it's just kind of repeating all of the stuff that the expert talked about here. But they say things like, the problem is that people have your self-perception is going to incline you to believe you can be fair. You're going to underestimate your own bias. You're going to overestimate your ability to be able to put all of that information aside and not have any preconceived notions about it. And a lot of this stuff is happening below your conscious level. You're not making a conscious decision, oh, I'm going to incorporate this news story that I just read into my worldview, and I'm going to shift my bias slightly in this direction because of that. That's ridiculous. That's not how it works. This all happens on the subconscious level. So of course you're not aware of it. So of course you're not going to be able to disclose it if people ask you in jury selection. So anyway, that had come up. I came across that and just found that was kind of an interesting little piece of synchronicity. So as it turns out, this is kind of the epilogue to that story. The U.S. Supreme Court said no. They reversed the circuit court. They said no, the trial court did not have an obligation to ask these very specific questions because the only thing that the court needs to be concerned about is bias, not what specific media items were you exposed to. And so if you can adequately explore the topic of bias without having to ask these specific media questions, then you're not required to ask these specific media questions. So where does that leave us? Well, the court isn't going to be required to ask about this in voir dire as a constitutional kind of floor. And that's because judges don't like making rules to require basically trial judges to have to do things of their own accord without being specifically asked by the parties. This is kind of one of those, I guess, dirty secrets from the practice of law that, not everybody has time to read all of the advance sheets that come out. There is so much law already, and there is more law being made every single day. It is voluminous, it is constant, and keeping up can be a challenge. And when you're a judge with a full docket and you got to set, all day hearings to hear from some venue change expert, it just takes away from your time to be able to stay up on the developments of the law. So they don't want to create rules that judges have to know about in order to do their job effectively, because the reality is, a lot, if not most judges just aren't going to know that they have to do that. It's going to create a lot of errors. But that doesn't mean that Ann Taylor and her team don't still have to ask those questions to be effective advocates. They are subject to standards that apply to death penalty qualified attorneys, that require them to fully investigate, requires them to assert valid claims on their client's behalf. And so they would be very remiss if they were not pointing out all of this stuff about how you cannot assess bias without asking these particular questions. They have to ask the questions if the questions are legally allowed. And for all the reasons we've talked about with the non-dissemination order, the standard that applies to, being able to gag attorneys from talking about their cases, looks to me like these questions are legal. So given that, yeah, they really have an obligation to be doing what they're doing. Well, I want to go ahead. I had a really hard time keeping up with the chat today, guys. I'm sorry about that. It's just, I'm still getting used to this whole streaming thing, and there's a lot going on. So couldn't necessarily catch everything. I did see some super chats. I pulled them up as they came up, but I did want to just go ahead and call them out. Thank you for the Isaac Bruce and Morgan Tremaine. You are so welcome. The entire reason I started a YouTube channel was literally to make that series about Isaac Bruce's cross-examination, because it was just so phenomenal. It was such a masterclass. He was such an ideal witness, and it was such a just bomb of a cross-examination, like a law school level what not to do on cross, that I was like, if nobody else is going to make this content, I have to make this content, because that is something that I would love to see on the internet. So I did. So I'm really glad that other people appreciate that as well. A super sticker. Thank you so much. And then the judge isn't going to allow him to continue, is he? Well, at this point, I mean, you heard my prediction. I think there is a pretty good chance that he's going to take that narrow little opening and say, well, as long as you fix the introduction to make it clear that these questions, these media items that we're asking you about are not necessarily reporting factual information or are not necessarily reflective of evidence in the case, then I think it'll be allowed to go forward. It was just, this was too good of a record of why to do it this way. And the state, despite having now, lots of time to get their own expert to come in and rebut this expert and, have something besides just Bill Thompson's knee jerk, I don't like this, I don't like this. They didn't do that. So this expert was very impressive. He's gone unrebutted in the record for why it needs to be this way. I felt pretty persuasive. Even, if the judge didn't completely understand all of it, I do feel like he understood enough that he gets why you need to do this, why it doesn't do you any good to just measure what people haven't seen. You have to get that information about how that false information has spread in the community. And I think also Elisa Massuth, she did a fantastic job of tying that in with the legal standard, that the falsity of the information that's permeated the community, that's a factor that they have to consider. And so if you haven't evaluated that, if you haven't measured that, then how on earth can you possibly make a ruling on that question? Love your background and your thoughts. Thank you so much. My background, I've moved things around a little bit in here. I used to be sitting in a corner, and so you had a little bit of a better view of my fish. It's just a flat wall now, but they're all still back there. I might tweak them a little bit, move them around, but yeah, still love my fish. Thank you so much. And then I second that. Coincidentally, I just re-listened to the Isaac Bruce series. Oh, I'm so glad. I really appreciate it. I love that Love that series. I wish that there were more witnesses out there like Isaac. He was such a great topic for a video series like that, mainly just because, I mean, well, I've already raved on and on and on about what a good witness he is, but also it was short, you know, it didn't take like a long time to go through the whole process, like evaluating somebody like a Dr. Hughes or a Dr. Curry, or, you know, one of these more extensive fact witnesses would have required. So anyway, I just loved Isaac, and I'm really glad that you guys liked Isaac as well. And I'm going to shout it loud and shout it wide. We have confirmation of some very important things. Stalking is false. Social media following is false. And something that I really think can't be understated, a lot of people are going to underestimate this, but the defense coming out repeatedly saying they believe in Bryan Kohberger's innocence, this is really significant. I know a lot of people are going to think, oh, defense attorneys always say that. Defense attorneys always think that. Oh, no, 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 no. Oh, no, quite to the contrary. Defense attorneys almost never think that, okay? If you get all of your perspective on the criminal justice system by watching these high-profile cases, then you might get the impression that that's how most of these cases are. But if you go down to your courtroom, your local courthouse on any given day of the week, and you sit yourself through a criminal first appearance docket, just sit through the first appearance docket. That's when everybody who has gotten arrested within the last like 72 hours or so, they need to be brought into court. Probable cause needs to be evaluated. Bail needs to be set. Basically, they need to have some type of preliminary court hearing following an arrest. And you will see that just the overwhelming volume of cases that go through a courthouse, they are not complicated. They are not involving, you know, significant risks of getting the wrong guy or whatever. I mean, a lot of times people are caught completely red-handed. It just is what it is. That's not to say that defense attorneys don't still have an important role to play in those cases with making sure we're charged with the right crime, we're being treated correctly, respectfully, with dignity in the pretrial process, pretrial incarceration, all of those types of things, and to advocate for some kind of sentence that is beneficial to the community, to the victim, and to the defendant. So yeah, even when your client is caught red-handed in the act, you still have work to do as a defense attorney. You don't just write that person off. But that said, when you see this volume of cases and you read the thousands and thousands of police reports that come in over these cases, no, you do not walk away with a knee-jerk reaction that everybody is innocent. Most criminal clients, this is just the reality, are not very smart. They're not very good at what they do. You know, if you were a better thief, you wouldn't get caught kind of situation. So when a defense attorney actually does think somebody is innocent, that's a little bit more of a bigger deal because it is rarer. And to put it out there like that too, explicitly to put it out there like that, that is quite unusual. Now, I understand there's some motive to do that in this case because it's a high profile case, because like we've talked about with this gag order, they're really limited on their ability to get Bryan's side out into the public record. This is one of the reasons why way back in the early days when that public defender from Pennsylvania was doing the media tour and lots of people were horrified by that. I was like, oh, this guy's a G, like go get him. He is the only one that is out there trying to even the playing field on behalf of this guy. That's a real defense lawyer right there. To come out and lay their marker out there that they think he's innocent. They are staking their credibility on what they think the evidence is going to show, because people are going to remember that. I mean, maybe obviously not the jury. Hopefully the jury is not you know, the jury that they end up with, we hope is little exposed to any of this as possible, coming in with as clean a slate as they can. But everybody else who's following this case, everybody else in the state, the 97% or whatever who have heard of it, yeah, they're going to remember, oh, if Ann Taylor said this guy's innocent and the evidence comes out that makes him look, you know, beyond guilty, well, now nobody's going to believe anything that she has to say. And the problem with the defense attorney, which is your position, is that people are already disinclined to believe you just because you're the defense attorney. People are already assuming that, you know, you are a terrible person, you're defending criminals, you're looking for ways to get them out on technicalities and so forth. So your credibility is really, really precious. I don't think that they would squander it to make a statement like that so explicitly and so directly if they did not actually mean that, if they did not actually believe, based on what we've seen in this 51 terabytes of evidence that the state has turned over, we don't think that he committed this crime. So yeah, I think that's very significant. I think it's going to be, you know, underappreciated, but I do not underappreciate it at all. So with that, I guess we know we have a hearing coming up still in May for discovery stuff. May is going to be interesting because we're going to have the Richard Allen trial coming up, and I have been doing a little bit of work to try to get caught up on that case so that I can be informed and hopefully follow that a little bit closer. So there may be a scheduling conflict there. I don't know. We're going to have to see how that pans out. But then obviously this motion now hearing on June 27th at 10 a.m. Yeah, well, that one's going to be a big deal. We're going to get a lot of these details from what the survey has found, any kind of counter response that the state has. It's going to be very significant. Changes of venue are really hard to get. I mean, for all the reasons that she described, the standard is very unfavorable to the defense. And being able to make that factual record of bias is a critical part. So if the survey is allowed to go forward, well, frankly, even if it isn't, and they just use what they have from Latah County, God, thank God they were allowed. They managed to finish at least that much. So if nothing else, even if they can't do the comparative surveys for other counties, at least they got the information that they needed for Latah County. But the presumption is very heavily against them because, you know, a lot of this thinking, this understanding about human cognition and bias and perception and how all of this stuff works, this is really kind of new, guys. It seems maybe not that revolutionary to a lot of us, but I mean, it was really in the 90s when most of these ideas were really starting to be developed. People were starting to understand, like, for example, memory. Oh, memory doesn't work like a video recorder. It's more like a constant process of revising, rewriting going on in your head. And every time you remember something, you're telling a different story. You're rewriting a story. It doesn't fit with how we like to think that human brains work, but the same thing is there with things like biases and how exposure to information can affect you and all of this stuff. This is new, and the law does not respond well to new information, new science, new technology, things like that. The law is a very, very slow moving project. So the legal standards are all based on ideas that can go back to, you know, the 18th, maybe 17th centuries about how human brains work and how people behave and how they make decisions and stuff like that. That's just one of the challenges we have with having a law that's based on precedent, that, you know, we have the standard of stare decisis. You follow decisions that are made in previous cases. Well, that means that when your previous cases are 300 years old, based on 300-year-old knowledge, you're kind of stuck with that unless you have a pretty good reason to depart from it. And courts are not, they're not very good at departing from what they have done in the past. So even though it seems like, based on what we know about how people work in this day and age, how their minds work, it should be really easy to demonstrate and talk about bias and that type of thing. But there's still just this reversion back to the hundreds and thousands of cases that are already out there that basically say, well, if the juror gets up on the stand and says he can be fair and impartial, then there's no challenge, there's no challenge for cause, there's no bias there. And that's just not realistic, given what we know. So very difficult legal standard for them to meet. I think it'll be an interesting hearing. I've gone back and forth on this change of venue multiple times. I do remember a question I saw in the chat: what happens with the judge and the prosecutor if they change venue? So the prosecutor will go with the case. In this particular situation, Bill Thompson is like the he's like the nominal head, but he's got his own attorneys in his office, as well as attorneys from the Attorney General's office who are running the day-to-day stuff on the case. We saw him deferring to them today because they're the ones that are going to be handling the motion for change of venue, not him. So they will follow the case to whatever county it ends up in. With the judge, it is discretionary. He might go with it, he might not. It's basically up to him. And there are reasons, at least I think, to think that he may not follow the case. First off, he's the administrative judge for the judicial district that they're in, the 4th Judicial District. And that's not necessarily like a huge job or anything, but it does mean he's in charge of more than just his own courtroom. He's got to, deal with new technology, contracts for courts in that circuit. He's got to deal with changes to the court rules. He's got to deal with personnel issues. I mean, those administrative types of things that come up as part of the business of running a court, that's his job. And so for him to be taken away from that, for however long it's going to take for this trial to go on, which I think we can anticipate it's going to be a long trial. That's going to have an impact on potentially those other courts in that district. So I could see him declining to follow the case because he's got these other administrative responsibilities. Another reason is just because so typically, one of the challenges, one of the reason why it's good that they're doing this change of venue motion now instead of just the way it often happens, which is you wait until jury selection, you get the panel in, you find out how pervasive the media exposure has been, and then if your panel is obviously tainted, that gives you your record to be able to move for a change of venue. But that's really inefficient in a case where it's complex and you can anticipate there are going to be lots of pretrial rulings. There are going to be motions to suppress. There are going to be motions in limine to talk about, you can admit this, you can't admit that. If you admit this, you need a limiting instruction for it. If you're going to cross-examine on this line, it needs to be constrained within these parameters. There's going to be all kinds of decisions like that have to be made up front. And so if those decisions have already been made, and then you disqualify the jury and you move it to another county, a new judge, he's not only going to have to get up to speed on what is this case even that I'm having a trial on in front of me, he's going to have to be brought up to speed on all of those pretrial rulings and stuff as well. So it's just a lot for somebody new to be, handed on their plate and kind of expected to deal with. If the case is going to be transferred now at this early stage, then whoever gets the case is going to be in the position where they will be the ones making the pretrial rulings. They won't have to have that, get up to speed at the last possible minute type of challenge. It's just a smooth opportunity to have a handoff to somebody new. They'll have plenty of time, a year, more than likely, to be able to get familiar with it and make those rulings and stuff. So, yeah, don't know for certain if he would go with it or not. It would be up to him. I suspect he would not. This has been eye-opening for me too, just from a factual standpoint, what the expert had to say today about the extent of the bias in the community. And, I guess it's it's important that they did it, and it's important information that they get. It's disappointing to me because honestly, I didn't think it would be that bad. I really didn't. And I guess I don't really know why. That was kind of my knee-jerk reaction. I guess because I thought that in a community where this happened to them, okay, this happened in their community. They talked about one of the jury questions had been about have you heard, seen, or read that the families of the victims were living in terror, or like students and their families were living in terror until Bryan Kohberger was arrested. And I can understand that. It was like a month between, the time of the murders and the time that he was arrested. So there's this extended period of time where this gruesome crime has happened. Nobody knows why. Nobody knows anything about it. Of course, you're scared that this might happen again. I guess I just thought that a community that had that type of experience would be really heavily invested in getting the right guy, not necessarily just this guy. And so I guess I was hopeful that there was going to be more of the I don't have an opinion types of responses than it appears. In fact, there were. So that's good. I mean, that's the reason to do these surveys, because my knee-jerk reaction, it seems like, would have been wrong. Now, one of my other reasons why I have been unsure about the change of venue also has to do with the potential for losing Judge. And I say this, I recognize, we've criticized Judge a little bit over the last couple of hearings, and people have, all different opinions, and they're totally entitled to them. My perspective is that relative to what you can expect from a rural Idaho judge in general, they have an absolute gem in Judge. They have somebody who is willing to consider defense arguments, be receptive to them, be, ostensibly polite to them in court. Gotta tell you, somebody's practiced in small rural counties in criminal defense. It doesn't always go that way. A lot of judges are prosecutors in robes. You could do so much worse than Judge. And so that to me is one of the risks that they have to take into consideration. Now, I suppose the common wisdom is, well, you go to Ada County, and it's big, and it's rural, and it's urban. I mean, and it's probably a little bit more blue state, I guess, than the rest of the state. And those things are all probably true. But there is no guarantee you go to Ada County. You could go to Shoshone County. You could go to Nez Perce County. You could go to any number of other counties. And in any of those other counties, you just don't necessarily have the same likelihood of getting a judge who will be receptive to defense arguments like this. So that is one of the things they've had to consider, and that is a risk. If the county is too biased, then the county's too biased, and that's just going to be the consequence that you have to deal with making that motion. But I mean, I'm not going to lie, I still would hesitate. I would be concerned about the risk of getting a judge that is much more of a problem than Judge has appeared to be so far. Love your point of view. I've enjoyed your previous experience, previous videos and guest room appearances, but didn't go back as far as Baruch. We'll put it on my next to watch. Yes, please do. Please watch the Isaac series. I'm still to this day, obviously, very proud of it. It was extremely fun to make. And I'm glad that people get so much enjoyment out of it. Oh my gosh, guys, it's been almost 4 hours here. I cannot believe I've done an almost 4-hour live stream. That's kind of nuts to me. So I'm going to go ahead and wrap it up. Like I mentioned, I'm going to be jumping over onto the stream with Ian Runkle pretty shortly. So Runkle of the Bailey, you can go check him out if you want to see me follow up on what we'll be talking about there. And I might, grab something to eat and drink real quick before I do that. But I'll be heading that way. So I'm going to go ahead and wrap this one up, guys. I will let you know when we do the next stream. And thank you so much for being here. Thank you so much for your support. I will look forward to seeing you next time. Bye-bye.